Good morning.
Good morning, Your Honor.
Morning, Your Honor.
I'm in the PC court classroom. I'm getting pretty nervous.
I'd have PTSD if I was there.
Last night I was sitting there and Louis Muldrow was staring at me the whole time. I'm like, oh my gosh. Mr. O'Neill, here's a quarter. Go call your parents. They wasted all their money.
Jeff and I didn't have an experience quite that scary, but it was close.
Did you all get the T-shirt for 100 years of practice court, 100 years of feeling fun? What a treasure, though. Truly, I mean, it's very difficult going through it, but wow, it's wonderful when you're out practicing.
There have been many times over the past 13 years where I've been late at work and man, this is tough, but hey, it's not practice court.
Yeah, so very true.
That was exactly my question to Ren going into it. I said, all right, I feel like I'm about ready to run the gauntlet or something, and that's fine, but just tell me there's a purpose for it, and what the heck is it for it being that bad? And that's exactly what he said, Jeff. He said, it's going to be worse than anything else you'll ever experience in practice, and you need to know that you can do it. Okay, all right. As long as there's an intentional purpose, I'll make it happen. And I barely did.
But that's why even for those that are going to go transactional or whatnot, just going through that experience, it's like, you'll be fine if you can survive that. And that's, with PC being at the end in our 3L, most schools, where my daughter and her husband went, 3L, it's a fun year. Yeah,
cruising.
I mean, you're coasting. And I'm like, no.
We had a T-shirt in our time at Baylor that said something along the lines of, at most law schools, 30 years a joke. At Baylor, the joke's on you.
Yeah.
Okay, that's awesome. That's awesome. So,
James, how are things out you're in Phoenix, right?
Yeah, they're great. They're great. It's a good place to practice. It's starting to get hot right now, so I'll do the obligatory, it's a dry heat and all that nonsense. But the rest of the year, I mean, it's a fantastic place to be, and it's a really good legal community. So enjoying it quite a bit.
We had a firm retreat out there last February. It was the last trip I took before the pandemic hit, out in Scottsdale, and it was beautiful.
Yeah, one of the resorts and golf and all that.
Boulders, I think.
Okay, yeah, great. Yeah, it's a neat place. When we flew out here to take a look at the firm, my wife's looking at mountains and palm trees and all this and going, that's different than what I expected it to look like. So, of course, they brought us out in March, so that wasn't quite fair.
Right, exactly.
Smart firm.
Good selling job.
All right, I think we have everyone other than our witnesses, so let me get everyone admitted. Good morning, counsel.
Good morning, Your Honor.
Good morning, Your Honor.
Do we have our witnesses?
I believe we're still waiting for the plaintiff.
Got signed out of your courtroom, but we're signing them back in now.
Okay, thank you. That was just explained to me that we are waiting for the witness to sign back in. With that in mind, we can proceed, though, with pretrial and housekeeping matters. So for those purposes, I will call the case of Jordan Gilmore versus Chimes Department Stores, Inc. For announcements. Plaintiff?
Yes, Your Honor. My name is Jack Kasemsi. My name is spelled on the screen, but if you need me to spell it for you, let me know.
No, ma'am.
I am joined with my co-counsel today, Jared Koenig, and we represent the plaintiff in today's case, Jordan Gilmore.
Defense?
Good morning, Your Honor. My name is Joy Holden. I'm joined along with my second chair, Nick Beachy. Today we represent the defendant in today's action, Chimes Department Store.
All right, do we have any housekeeping matters? From
Yes,
plaintiff?
yes.
Proceed.
Would you prefer that when we're entering in evidence, we screen share it while we lay the foundation? Or would you prefer that we ask the witness to find the exhibit in their own case packet and we only screen share once it's been admitted?
I would screen share while you're laying the foundation, and that will be done constructively.
Additionally, Your Honor, when entering an exhibit into evidence, would you prefer that it retain its labeled exhibit name?
Yes.
And lastly, Your Honor, before we proceed to our pretrial motion, we and the defendant have agreed to the stipulation of pre-admittance of certain exhibits.
All right.
We have stipulated to the pre-admittance of Exhibit 3, 5, 6, 11, 17, 18, 19, and 33.
Is that correct, defense counsel?
Yes, Your Honor.
Anything else housekeeping wise from plaintiff?
No, Your Honor.
Defense, any housekeeping matters?
No, Your Honor.
All right, we'll proceed to pretrial substantive matters. Plaintiff?
Your Honor, at this time, the plaintiff moves for the court to take judicial notice of two regulations. The first is 29 USCS, Section 654.
Do you have a screenshot for me?
Yes. Yes, Your Honor. Let me go to that. It's a little hard to find the regulations because they're just at the beginning.
And while she's doing that, defense have any position on that?
Your Honor, this is a negligence case. It's not a negligence per se jurisdiction. So while Your Honor certainly can take judicial notice of this statute, it doesn't actually go to the facts of this case or the law.
Well, law is generally recognized judicially by the court counsel. So I'll do that, but whether or not it's something that can be utilized in the trial of this matter remains to be seen.
Yes, Your Honor. And then the second statute that we are asking that the court take judicial notice is 19.
Again, counsel, if it's the law, I'll take judicial notice of it, but that again does not mean it. I'm agreeing for its use in the trial of this action. You will have to lay proper predicate at that point in time.
Yes, Your Honor, we will do that. And this is the other one that we just wanted to show you.
Thank you.
At this time, the plaintiff is ready to proceed, Your Honor.
Defense have any substantive pretrial matters?
Yes, Your Honor, we do. We move to exclude Exhibit 14 on the basis of hearsay within hearsay under Rule 805 and improper propensity evidence under Rule 404. Could I ask my co-counsel, Mr. Beachy, to screen share Exhibit 14 for Your Honor? This is Exhibit 14, Your Honor. It's a prior instance of someone being harmed or being injured, outside of the defendant's property. The plaintiff today, we believe, will be using this evidence as propensity evidence, saying that because someone was hurt in the past, it would make it more likely that the plaintiff today was harmed. Additionally, Your Honor, there are two layers of hearsay that the plaintiff will have to come over. First is the person giving the interview. A second is the interviewer who took that person's statement. Both of those statements are inadmissible because they're hearsay within hearsay under Rule 805.
Response?
Yes, Your Honor. The response to the hearsay within hearsay, first and foremost, it's important to establish that this is a recorded statement guide from the defendant party. And the only people who filled this out were employees of the defendant. The form itself is made by the defendant, and the narrative is made by an employee who was in employment at the time. And thus, the narratives parts of this and the filled out parts are an exception as statements made by the opposing party. For the first layer of hearsay, Your Honor, this is an exception to hearsay because this is a business record that the defendant did in fact use whenever they would evaluate any incident with an employee.
May I respond to that?
You may.
Counsel will need to lay foundation that this person was actually an employee of the defendant working in the course of employment when he fell.
Counsel, I agree with you with the idea of foundation. And that's why for now, I'm going to overrule your in limine. We'll take that up at the point in time in trial and see what the circumstances are for its use or whether or not it will be excluded at that time. I really don't want to hear a whole lot about the recorded statement in opening statements, however.
Yes, Your Honor.
Anything further?
No, Your Honor, the defense is ready to proceed with opening statements.
All right. Well, with that in mind then, at this time, call for on the merits, the case of Jordan Gilmore versus Chimes Department Stores, Inc., both parties having made announcements of ready. Plaintiff may proceed with opening statement.
May it please the court. Business first, safety last. That, members of the jury, is the mindset of the defendant that led to Jordan Gilmore, the plaintiff in today's case, being injured from falling off a makeshift loading dock. Because the defendant had this business first, safety last mindset, they created a hazard when they decided to turn an emergency exit into a loading dock. Because of this mindset, the defendant forced their employees to go out onto that makeshift loading dock for multiple tasks that had nothing to do with unloading and loading trucks. Because of this mindset, the defendant chose not to put any safety regulations on that makeshift loading dock or the stairs that the employees had to use to get down from it. We're here today because the defense chose business first and safety last. Today, you guys are going to hear from the plaintiff in today's case, my client, Jordan Gilmore. Jordan Gilmore was a dedicated employee to the defendant for 10 years. Jordan Gilmore was a cashier and started using that makeshift loading dock to take out trash because that was where the defendant put the dumpster. In 2015, the defendant implemented a smoke break policy to where not only would employees be forced to go out there to take out the trash, but they would also be forced out there if they wanted to take a smoke break. And that policy is what led us to the injury of Jordan Gilmore that brought us here today. That injury occurred on January 23rd, 2019. It was a cold day in Texas, and Jordan Gilmore was working a long shift at the store. It was time for a smoke break, so Jordan asked their coworker, Riley, to go out with them. They went out those back doors that used to be for an emergency exit and out into the loading dock. When they went out there, it was pitch black. The reason why it was pitch black, members of the jury, is because there was no lighting out there whatsoever. On that area, that loading dock that the defendant was forcing their employees to go out on. As they got out there, Riley, the Jordan Gilmore's coworker had to keep the door open in order for any light to be back there. Jordan Gilmore decided to walk down the platform whenever they took their smoke break. So as he walked down, he had to hold on to the wall to steady himself because there was no railing. Jordan Gilmore got down there, took a smoke break in the dark, and then he went back up those stairs, having to hold the wall all over again. When Jordan Gilmore got to the top of the stairs, Riley was still holding the door open to let light out. And so Jordan had to let go of those stairs as he stepped onto the platform to go around the only source of light. And in that moment, his foot slipped and he fell off the loading dock. The loading dock that used to be an emergency exit. This loading dock that used to have railing there. That would have stopped Jordan Gilmore from even trying to go around that door. And that's when Jordan Gilmore was injured. We're here today because we've brought a claim of negligence against the defendant. And so we have a burden of proof today. We have to prove to you by a preponderance of the evidence that the defendant was negligent by allowing an unreasonable risk to be there when they created that loading dock, by knowing about the conditions.
Counsel, I've lost you. The audio is not coming through. Now it is.
It is.
Yes, ma'am. Proceed.
Your Honor, if I may ask, which part did I cut out on?
Very brief time period before I announced that I couldn't hear you.
Yes, Your Honor. We have to prove to you by preponderance of the evidence the negligence of the defendant. A preponderance of the evidence simply means more likely than not. So if you want to think of a set of scales, and on one side is all the evidence in favor of the defendant, and on the other side is all the evidence in favor of the plaintiff. If those scales tip even slightly in our favor, then we've met this burden. In order to meet our burden of proof, we want you to get to know Jordan Gilmore. So we're going to call Jordan Gilmore to the stand. He's going to tell you about working at Chimes, and he's going to tell you about the conditions of that makeshift loading dock. We're also going to call Kate Danes to the stand, a mechanical engineer who's going to talk about all the safety regulations that employers need to have in order to ensure the safety of their employment area. And then we're going to get to talk to Reese Geller, the owner of the defendant company. And Reese Geller is going to have to admit to you that they chose to turn an emergency exit into a loading dock, that they chose to take the railings out of it, that they chose to force their employees to go back there for many tasks that were not unloading and loading trucks. And Reese Geller is going to have to admit to you that they did nothing to make that area even remotely safe. When the defense presents their case, when they come up here and talk to you, I want you to ask yourself, and when you listen to their evidence for the entire trial, what did they do to ensure the safety of their employees? What did they do to make sure that employees like Jordan Gilmore were safe when they were forced to go outside onto the makeshift loading dock? And at the end of the trial, you're going to see that for the defendant, it was business first and safety last. And because of that, we'll ask you to find the defendant liable.
Defendants wish to make an opening statement?
Yes, Your Honor.
Proceed.
May it please the court.
Proceed.
This is a case about choices. Choices that the store couldn't change. Ms. Kazemsi just told you that her client got hurt of falling off of a loading dock. And members of the jury, that's true. She told you that whoever was in charge of that dock might be responsible. That's true too. But then she tried to tell you who that was, claimed that the loading dock was the responsibility of Chime's department store. I told you that it was the store's fault. And members of the jury, that's just not true. You see, Chime's department store is only one store in a whole shopping center. They don't own that building. They rent it. You'll learn that the actual owner, the landlord, is a corporation called Kermit Realty. They chose to build that loading dock where Mr. Gilmore fell. They chose to take responsibility for maintaining it, and when something happens because of their choices, they're the ones who are accountable. Members of the jury, that matters, because that landlord, and not the store, is the one with the legal duty to repair that dock. That landlord, and not the store, makes choices about when to fix those stairs, and that landlord, not the store, let those lights go out and let those stairs crumble. And so today, the plaintiff is asking to hold Chime's department store liable for someone else's choices, choices that they just couldn't change. Good morning. My name is Joy Holden, and I represent the defendant in today's action, Chime's department store. Those choices that Chime's couldn't change, they matter because today the plaintiff has the burden of proof. They have to convince you of four things, more likely than not. First, that they owed Mr. Gilmore a duty, breached that duty, that Mr. Gilmore suffered injuries, and finally, that the breach was the direct and proximate cause of those injuries. Members of the jury, the plaintiff today won't even be able to meet the first element of their burden, duty, because it was Kermit Realty, not the store, that had control over that loading dock. To see why the plaintiff will fail to meet their burden, you'll hear from the owner of Chime's department store. In fact, Mr. Geller, could you turn on your camera a moment so the members of the jury can see? Ladies and gentlemen, this is Reese Geller. He's the owner of Chime's department store. He'll tell you how Chime's department store is a family business. It was passed down from his grandfather 3 generations to him. For the past decade, Mr. Geller has been responsible for running that small business and serving our community. And thank you, Mr. Geller. You can turn your video off. He'll walk you through the lease that they have with Kermit Realty Group and explain exactly which choices his store can and can't make. You're going to see that the parking lot in the front, they're responsible for that. The building, they're responsible for that too, but the alley in the back, the loading dock where Mr. Gilmore got hurt, you're going to hear that they were not contractually responsible for that. You'll hear that Kermit Realty is the only one in charge of making sure conditions on that loading dock were safe for tenants. But you'll see that the landlord's choices aren't the only ones that Chimes couldn't change. Because the plaintiff, he made his own choices that day. We expect that the plaintiff will testify that he's walked up and down those stairs thousands of times before January 23rd. In rain, at night, in all sorts of conditions, without any problem. We'll expect that he'll admit that day he got hurt, that was different. On that day, he chose to walk on the very edge of the stairs, these stairs right here. And the evidence will show that he didn't have to make that choice. And that on that day, he lost his balance. Another employee reached out to try to grab his hand and help, but instead of taking that employee's hand, the plaintiff chose to jump He chose to jump off those stairs instead. You'll learn how that night the plaintiff made choice after choice that Chime Store just couldn't change. That's why we've also raised an affirmative defense of contributory negligence. And that means that if we can show that it's more likely than not that Mr. Gilmore acted unreasonably that evening, that he didn't exercise ordinary care, we can hold him partially responsible. So as you listen to all of the evidence today, I want you to think about what Chimes did and didn't have the power to do. Did they have the power to change the property that they didn't own? Did they have the power to change the plaintiff's choice? We expect you'll find the answer to those questions is no. Chimes department store didn't have a choice. But you will. That's why at the end of today's trial, I'll come before you again, and I'll ask you to find for the defense. Thank you.
Plaintiff, call your first witness.
Your Honor, the plaintiff calls Jordan Gilmore to the stand. May I proceed, Your Honor?
You may.
Good morning, Mr. Gilmore.
Morning.
Please introduce yourself to the jury.
Hello, my name is Jordan Gilmore. Nice to meet you guys.
Where do you live right now, Mr. Gilmore?
I currently live in Waco, Texas.
And what's your job here in Waco?
At the moment, I'm unemployed, actually, so I don't work anywhere.
Did you have a job before you were unemployed in Waco?
I did, yes. I was a cashier at
Where-
the Chimes department store.
What is Chimes department store, Mr. Gilmore?
Well, it's sort of a low cost department store. It doesn't specialize in a particular sort of item. You can get a lot of stuff there. It's sort of, I guess I'd liken it to maybe like a Sears or a Macy, but not necessarily as high end, but that sort of concept.
Okay. How long did you work for Chimes department store?
It's quite a while. I would say it was about 10 years.
All right. And Mr. Gilmore, we're here because you were injured. Were you employed at Chimes department store when you were injured?
I was employed by Chimes, and I was working a shift when it happened, actually.
You said you were working a shift when you were injured. Where did the injury occur?
The injury occurred out back at the loading dock area behind the store.
Why were you at the loading dock if you were a cashier?
At that time, I had gone to take a smoke break. I do smoke cigarettes, and we had been sort of instructed by Chimes not to go smoke out front at the front of the store. So we were told go to the loading dock, smoke there. So I was just following instructions when I went to go take my smoke break.
Were you formally sent any information about this smoke break policy about going to the back?
I got an email, I believe, from Chimes. If that's what you mean. I'd say that's the formal notification I got.
Mr. Gilmore, would you recognize that email if I showed it to you?
I would, yes.
Your Honor, permission to screen share.
You may.
Mr. Gilmore, what is this?
So that would be the email I was referring to. That's the message that sort of told us, do not smoke out front. Go to the back on loading dock. Take a smoke break there.
Who sent this email to you?
So that would be Lane Kim. She was my manager at Chimes department stores.
And who did she send this email to?
It was everyone that worked there, including me.
At this time, Your Honor, plaintiff moves to enter Exhibit 1 into evidence.
Defense,
No objection.
1 is admitted.
Mr. Gilmore, since we were laying that foundation, can you quickly just explain to the jury what this told you?
Yeah, so it basically just told us where we were supposed to take our smoke breaks, and that was not at the front where the customers would be, coming in and out of the store. It was to take it out back at the loading dock.
Thank you. Mr. Koenig, could you please take this down? So when you went out to take your smoke breaks, how many back doors were there?
How many back doors? I believe there was just the one, the door that led out to the emergency dock.
And besides smoke breaks, were there any other reasons why you had to go to the back of the store for your job?
There was, yes. The dumpsters were out back behind the store, so we would have to take that door at the loading dock and go out that way if we wanted to take out trash to the dumpster.
So if you were working at the cash register and you had to take out the trash, how would you get to the dumpster exactly?
Well, I go to the back of the store, go out the door, and then there is a set of stairs that comes from the loading dock down to just the base level where the dumpster was. So I take the stairs, take the trash to the dumpster, and come back.
Would you recognize this loading dock with those doors if I showed it to you?
I would, yes.
Your Honor, permission to screen share what's already been pre-admitted as Exhibit 6.
You may.
Mr. Gilmore, what are we looking at?
So that's the loading dock, the back of our store, the exit to go for our smoke breaks or to the dumpster.
Could you tell us what this red sign on the door says?
Yes, that sign says "Do not block fire exit."
And then could you tell us what we're looking at the corner of the stairs right there?
Yes, so in the black circle is sort of what was formerly the corner of that set of stairs. It's started to crumble, and the supportive rebar lattice is exposed.
Thank you. Permission to publish to the jury, Your Honor.
Any objection?
No, Your Honor.
You may.
Thank you, Mr. Koenig. You can take that down. So, Mr. Gilmore, you keep referring to this as a loading dock. Why do you refer to it as the loading dock?
I mean, that's just kind of the only thing I ever knew it as. It wasn't sort of any written policy or anything referred to as a loading dock, but I mean, we use it as a loading dock, and that's just kind of how I'm referring to it.
When you started working at Chimes, were you ever informed that it used to be an emergency exit?
No, I mean, like I said, as far as I'm aware, that was the loading dock. That's how it was used. That's how we knew it as. I'm not familiar with it being anything other than a loading dock.
Were you ever informed that there used to be railing around that loading dock?
No, I don't remember there ever being any railing. I don't remember ever being told about any railing.
Were you ever told by Chimes department store that they had decided to remove railing that used to be there?
No, I had not heard that.
And since we established that you saw that sign on the door every time you went out about it being a fire exit, did an alarm ever sound when you'd walk
Objection,
in?
Your Honor. Counsel is testifying with her prior statement there. That wasn't established on the record.
Let's back up and lay proper foundation, counsel.
Yes, Your Honor.
Strike that statement, Your Honor.
I'm gonna let her back up and proceed.
So just to remind the jury is what I was saying, what exactly did that sign say that we already pointed out earlier?
I believe it said "Do not block fire exit."
So when you went out those doors with that sign, did an alarm ever go off?
No, there was no alarm.
Mr. Gilmore, I want to move on to talking about the night of the injury. Do you remember the date of the night that you took that fall?
I believe that was January 23rd, 2019.
And why on that night were you out there?
At that time, I had gone out to smoke a cigarette.
Were you alone?
I was not. I had a coworker with me. Her name was Riley. She, I believe, also was taking a smoke break at the time.
And when you went out there, what time was that at?
It was towards the end of my shift. It was a 12 to 8 shift. I would say it was about 7 p.m. when I went outside for the smoke break.
Was the sun still up?
No, I mean, this is late January. Days are short. It gets dark probably more like 6:30. Earlier than I went outside. It was dark.
So if the sun was down, what lighting was out there, Mr. Gilmore?
Really, I mean, there's none out there. There's a light that we don't really get access to. We can't turn it on off, so it's not really useful to us. That's sort of it's the only external light. So we sort of just have to use the light that spills out of the door when we open it.
And who told you that you couldn't turn on and off that light?
I think that might have been my manager. I just know that the switch was apparently in the next door. It wasn't within the control of the store, was my understanding.
So if there were no lights, the sun was down, did you guys just stand in darkness?
No, Riley had sort of held the door open a little bit, and there was light coming from the store, and that sort of spilled out onto the loading dock, and that was the light we were seeing by. It wasn't much.
Where were you standing when you decided to take your smoke break?
So we had gone outside, and I ended up actually going down the steps, the loading dock. Riley stayed in the door frame, but I went down the steps.
Did you need any assistance from anything when you went down those steps?
Yeah, I mean, there's no railing anything. It's cold, it's windy, it's dark. I stayed up against the wall. I had my hand on the wall, kind of used that as a makeshift support, but there really wasn't anything like a railing.
So after you got to the bottom of the steps, what happened?
Well, then I took my cigarette break, which was about 5-6 minutes, I'd say.
And then did you decide you wanted to go back inside then, or was it later?
It was after I finished smoking. I ended up heading back up the steps to go inside, and
Did you have to hold on to the wall when you went back up too?
Yeah, I mean, there's no railing. It's sort of a precarious little walkway given the situation. So yeah, I was keeping contact with the wall.
When you got to the top of the steps, what was Riley doing at that time, Mr. Gilmore?
So Riley had been holding open the door. I assumed it was for the light. I couldn't tell you exactly when she was holding it open, but she was holding the door open as I was ascending the steps.
Your Honor, permission to screen share what's been previously admitted as Exhibit 3.
You may.
Mr. Gilmore, explain to the jury what we're looking at here.
So we're still looking at the loading dock we've been talking about, and that's with the door sort of open, kind of how it was, the way Riley was holding it. It's sort of blocking the stairs a little bit.
And so where are the stairs in this picture?
So it'd be the little tiny bit you see to the left of the door. Most of it's blocked by the door. You can't really see.
So when you got to the top of the stairs, what did you do?
Well, since the door was ajar, I didn't obviously have full use of the stairs, so I tried to get around it as best I could with the little bit of stair I had.
What happened when you tried to get around that door?
I unfortunately not quite keep my footing, and I began to lose my balance, and trying not to bash my head on the concrete, I sort of tried to hop off a little bit, keep my feet up underneath me as opposed to over my head, and landed very poorly.
Mr. Koenig, you can take this down. Mr. Gilmore, did Riley try to help you when you began to fall?
She tried. There wasn't really a lot that could really be done in that situation.
Explain to the jury how exactly you landed when you fell.
So, I mean, like I said, once I kind of realized I tipped too far to keep my balance, I tried to get off my feet a little bit to keep them underneath me. So when I landed, it was on my feet, but I didn't quite keep my weight distributed well. Kind of went down all on one side and just crumpled.
Did you feel any pain at that point?
Yeah.
Objection, Your Honor. Permission to be heard outside the presence of the jury.
Yes, ma'am.
As Your Honor knows, this is a bifurcated trial. Damages will be decided at a later date. So the extent of this witness's injury, the fact that he felt pain, all of that doesn't make a fact in this case more or less likely, whether Chime's department store was negligent.
Response?
Yes, Your Honor. This is a bifurcated case, but in order to prove liability, we have to show that the plaintiff was in fact injured, and that injury was a proximate cause of the negligence of the defendant. Since this all has to do with that loading dock and that fall, I'm just asking if he felt pain in that moment after the fall to show the proximate cause of the injury from that fall. We're not asking him to go into detail how much pain he felt. We're just trying to show the proximate cause of when he felt that pain.
Limit it to whether he was injured. And
Yes,
so
Your Honor.
I sustain the objection.
After you fell, did you go back inside?
I did, yeah. It wasn't quite the end of my shift, so I ended up getting off the floor and heading back in.
Did you tell anyone what happened?
I did, yeah. I went and I told the manager, Lam Kim, kind of details, sort of what I've just told you about the fall. And, you know, she kind of told me that they've been meeting to fix the stairs. They were kind of aware of the problem, and they just had other priorities, I guess.
Did you find out if you were injured from that fall, Mr. Gilmore?
I did, yeah. My knee was just destroyed. I mean, I had to get it.
Objection, Your Honor. Again,
Overruled. Go ahead.
Yeah, so I mean, I just destroyed the knee, total replacement, got the giant scar going all the way down my knee. I mean, very, very badly injured.
No further questions, Your Honor.
Cross?
Yes, Your Honor. Good morning, Mr. Gilmore.
Morning.
Those stairs you talked about on direct examination, you've been up and down them thousands of times.
Quite a few, yeah. I'm not sure about the number.
You worked at the same store for 10 years,
Yes, about 10 years.
and each and every day you would use those stairs, right?
As far as I can remember, yeah, pretty much every day.
Sir, you'd go down those stairs when you wanted to take out the trash.
When I had to take out the trash, yeah.
You'd go down those stairs when you wanted to take a smoke break.
That'd be correct, yeah.
And you'd go right back up those stairs to get back to work.
Correct.
All 10 years that you worked at Chimes, those stairs have been the same, right?
I mean, more or less. There's some wear and tear, but yeah.
The same loading dock
Yes,
with the same number of lights.
yes.
And so on the day that you were injured, sir, everything on that loading dock was the same as always.
More or less, yeah.
Sir, what you did was different.
I'm not sure how you mean.
Well, I'll explain, sir, but first, Mr. Beachy, can we have Exhibit 17, please? These are those stairs that you were talking about on direct examination?
That looks to be the staircase, yeah.
Sir, it's fair to say that that staircase, it has two sides.
So 2 sides?
That's right.
Yes,
One side, it's by the wall.
correct.
It's not possible to fall off that side, is it?
No, there's a wall there.
You can hold on to that wall for balance if you want to.
Correct.
But the other side, that's away from the wall.
Yes,
That's where the edge is.
correct.
You know it's possible to fall off of that side.
Yes,
Now, when you walked down the stairs that night, you walked along the wall, right?
correct.
You had no problem getting down, right?
It's a little bit precarious, but I made it down all right, yeah.
But you didn't fall off.
No, I did not fall on the way down.
But when you walked up the stairs, you walked on the edge, right?
Once I got towards the top, yeah.
The side without the wall.
Yes,
The side you knew you could fall off of.
yes,
And the reason you walked up that other side, as you testified to a little bit earlier, was because of a door that was blocking your way, right?
yes. The doors blocked the top of the stairs.
Your Honor, permission to show a demonstrative for the members of the jury. We showed this to opposing counsel and they had no objection.
Is that correct, counsel?
Yes, Your Honor.
Proceed.
Sir, this is a diagram of that loading dock.
Looks to be, yeah.
You recognize it, don't you?
Yeah, I mean, that matches up with what I remember about the loading dock.
Right, this matches up with what you remember about the loading dock looking like on January 23rd, right?
Correct.
And so on January 23rd, sir, you had to open that door, right?
Correct.
But you only opened that door halfway.
Correct.
I'm showing you for demonstrative purposes that door opened. Sir, this is what that looked like on January 23rd.
As I was coming back up the steps, yes.
And that meant that that door, it was blocking your way up the stairs.
Correct.
I'm highlighting a part of those stairs that weren't blocked by the door. Sir, that's the part of the stairs that you chose to walk up.
Correct.
So let's see what that looks like in a photograph. This is Exhibit 3. You recognize that too.
Yes, that's the loading dock.
That's the part of the stairs that you were trying to walk up.
Correct.
Mr. Beachy, could we highlight the visible stairs? Sir, that's just inches of space.
It looks about, yeah.
To be clear, Mr. Gilmore, your department store didn't ask you to walk up half a foot of stairs, did they?
They did not ask me to do that, no.
So let's look again at the demonstrative. You know, Mr. Gilmore, that door doesn't have to be halfway open.
Correct, it doesn't have to be.
You know, you can open it all the way, right?
Correct, it does open further.
I'm going to show you for demonstrative purposes that door swinging open. When that door opens, sir, you can walk all along the staircase.
Correct.
Could we highlight those stairs, please? When that door is open, you can walk right next to the wall, right?
Just about, yes.
That's not what you did on January 23rd.
No.
Instead, you chose to walk up those couple inches of stairs.
Yes.
That's when you started to lose your balance, sir.
Oh, when I was trying to go around the door.
And when you started to lose your balance, your friend, well, she reached out her hand to help you.
She did.
Sir, you didn't try to take her hand, did you?
No, I was already too far falling back.
Instead, you jumped.
Yes, I wanted to keep my feet underneath me.
Sir, you made a choice to jump off those stairs.
Yes.
Chime's department store certainly didn't tell you to jump off of those stairs, did they?
No, they did not.
Chime's department store didn't tell you to leave that door halfway open, blocking your way, did they?
No.
They didn't tell you to walk up just a few inches of stairs, did they?
They did not.
Those were your choices.
Correct.
Thank you, sir. Your Honor, pass the witness.
Redirect.
Yes, Your Honor. I just want to clarify for the jury what was happening before you reached the top of the stairs, Mr. Gilmore. Were you holding on to the wall when you were walking up those stairs?
Yes, as I said earlier, I was holding up the stairs as I went both up and down. But as I got to the door, I had to get around it. And at that point, that's when I lost contact with the wall.
So before you got to the top of the stairs, when, like you said, you had to use that little space, were you walking down the middle of the stairs?
I would say just middle or towards the wall. I was not skating the edge until it became necessary to skate the edge.
And when you were trying to go around that door, was that when Riley started holding out her arm?
No, she started holding it out once it kind of became clear that I was falling backwards. But really, by that time, it was too late. She meant well, and I appreciate the gesture, but she was not going to keep me from falling.
Objection to speculation.
Response.
Your Honor, this witness is allowed to testify to what they rationally perceived. Like they said, they were mid-falling when their friend Riley started reaching out. So they can say whether or not they thought that Riley reaching out was able to help them while they were mid-fall. They're not saying anything beyond that.
Overruled.
And lastly, Mr. Gilmore, why were you going out onto a loading dock in order to take a smoke break?
Because that's what Chimes told me to do.
No further questions, Your Honor.
Anything further from this witness?
No, Your Honor.
May the witness be excused.
Yes. And you may call your next witness.
Your Honor, at this time, the plaintiff, pursuant to pretrial orders, is going to read some lines from the deposition of Kelly Danes.
Proceed.
Starting on page 2, line 6. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
Moving on to line 12. Tell us about your education.
I have a Bachelor's of Science in Mechanical Engineering from the University of Wisconsin-Madison.
Moving on to line 24. I noticed that your CV lists you as a PE. What is that?
It stands for Professional Engineer.
What do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the Fundamentals of Engineering exam, which I did. Then you work as an engineer for 4 years before you take the Professional Engineering exam. So I took that as well, and I passed.
Moving down to line 13 on that page. What do you do professionally?
I am the president of Danes Engineering, LLC.
What does your company do?
Well, we provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits like this one.
Moving on to page 4, line 5. Do you testify mostly for plaintiffs or defendants?
Both, pretty even, really.
Moving down to line 14. Over the course of your career, how many incidents have you investigated over 60 years?
Over 60.
Oh, excuse me. And now moving on to page 5, line 14. All right, Kelly, I want to move on and talk about your work in this case. What did you review in coming to your opinions in the case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took pictures of that area.
Your Honor, at this time, the plaintiff moves to tender Kelly Danes as an expert in mechanical engineering with a specialization in commercial and construction engineering.
Defense,
No objection.
so tendered and accepted.
Moving on to page 6, line 6. All right, before we get to those opinions, I want to talk about your inspection of the premises. Did you take any photographs during the inspection?
I did.
Your Honor, permission to pull up what's been pre-admitted as exhibits 17 and 18?
Yes, ma'am.
I'm showing you what's been marked as exhibits 16 through 21. Do you recognize these?
Yes, I do. If you could give me one moment, please.
Yes, Mr. Koenig, we're on line 12 on page 6.
Thank you. You may continue.
I'll start at number 10 right there. I'm showing you what have you been marked as exhibits 16 through 21. Do you recognize them?
Yes, those are the pictures I took of the area outside the charm store where Jordan Gilmore fell.
What are these pics? Oh, moving on to line 18. What do these pictures show?
Well, as you can see, there are no railings on the steps up to that landing area, and there is no railing on the landing area itself. Plus, you can see where the railing used to go into the concrete and how the concrete around those areas is worn down and cracked. So you can see that this is a pretty dangerous situation.
Moving on to page 9, line 9. Mr. Koenig, you could take this down. All right, so which portion of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which we found in 29 USCS 654, and the maintenance provision under section 3401.2 of the IBC.
Why are those significant in this case?
These are general provisions that require an employer and or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free for recognized hazards. Here, as you can see from the photographs I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards. So fairly clearly, the defendant violated these requirements under both the IBC.
Objection, Your Honor. Improper expert opinion under Rule 702A. May I be heard?
You may.
Certainly, Ms. Kazemski has tendered this witness as an expert in engineering. He can talk about what hazards he saw. What he's doing now is opining on a legal standard, that those hazards broke OSHA law and other federal and or international law. That invades the province of the jury. It's the jury's choice to decide all of that information, not this witness's.
Counsel is an expert witness not allowed to opine on questions of law and fact mixed.
Yes, Your Honor, that's true. But what this witness has just done is invade the province of the jury. He's telling the jury what to do, and that's not proper.
Response?
Yes, Your Honor. We've already tendered this witness as an expert in mechanical engineering with the specialization in commercial and construction engineering. We laid out all the experience that this witness has inspecting different properties and seeing if they follow certain regulations. Opposing counsel had no objection to us tendering this witness as this. And thus, as an expert who's been tendered as this is what they do, they're allowed to say whether or not with their findings, when they inspect something like they've done many times before, whether or not it falls under regulations.
Please address her contention that it invades the province of the jury. Isn't the jury the fact finder?
Your Honor, experts are allowed to give opinions as to whether or not the things that they evaluated were true or not, or whether it fell underneath regulations, because that's what she's been tendered as an expert to do.
Final word, Your Honor.
Very briefly.
Certainly, experts are allowed to opine in their expertise, but this is a legal opinion. He's saying that the defendant broke the law, which is exactly what the jury is supposed to decide.
Well, he's opining on violations of the OSHA standards. The jury will be charged with determining negligence. Very close call, well discussed by counsel. I'm going to give you pretty significant leeway on your cross-examination, counsel, on that, but for now, overrule the objection.
Mr. Koenig, were you finished reading the answer to that question?
Yes, I was.
At this time, Your Honor, permission to screen share what we've just laid out as USCS 654.
All right.
Your Honor, this is just, this is the regulation that we just mentioned. At this time, the plaintiff moves to enter this and exhibit this regulation into evidence as Plaintiff Exhibit 1.
Defense?
We object, Your Honor, under Rule 401 and 403, if I may be heard.
Very briefly.
As Your Honor established at the beginning of this trial, this is not a negligence per se jurisdiction. If the jury has this law to take back to deliberation, they're going to think that if the defendant broke this law, then the defendant was negligent. That's not at issue today.
Sustained.
Moving on to lines, let me see, page 11, line 6. What other portions of the IBC codes and the OSHA regulations did you find important in this case?
OSHA 1910.37B1 and IBC 1006.1, which both deal with lighting.
Why are those significant?
Well, 1910.37B requires that lighting must be adequate and appropriate for a building exit like this one, and 1006.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above these stairs, but there was no switch for that light inside the Chime store. So there was no way for employees to turn that light on when they were outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they were stepping.
Line 24 on that same page. What's next?
Next, we move to OSHA 1910.23D1 and 1910.24H and IBC 1009.11.
Why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there was no guardrail on these stairs on the exposed side, which is obviously dangerous.
No further questioning of this from this deposition, Your Honor.
Defense?
Your Honor, we also intend to read portions of the witness's statement, a permission for my co-counsel to read it along with me, and to screen share portions of the deposition for the members of the jury.
We can read the examination. I'm not going to allow it to be presented to the jury by
Yes,
screen
Your Honor.
share.
So I'm starting on page 9, line 4. Question: do you know or have any opinion on who was responsible for the maintenance and repair of these steps behind the Chime store?
No, that's not what I was asked to do.
Page 10, line 4. Let me ask you this. If Chimes wasn't responsible for maintaining that area where the stairs were located in the back of the store, would the IBC apply to Chimes in regards to that area?
No, it wouldn't. The IBC applies to whoever has the responsibility to maintain that area, but the OSHA regulations apply to employers generally.
Page 10, line 19. Do the OSHA regulations place any requirements on employees?
Yes, there's a general duty requirement in 29 USCS section 654B, which says that employees also have to comply with the OSHA standards and regulations and basically have to be responsible for their own actions.
Thank you, Your Honor. We have no further questions from this deposition.
All right, anything further from the offer?
No, Your Honor, not from this deposition, but before the plaintiff rests their case in chief, we'd like to make a motion.
Outside the presence of the jury, go ahead.
Yes, Your Honor. We would like to move that conditionally Exhibit 14 and 13 be entered into evidence. The 14 is an incident report that Mr. Geller, the owner of the defendant, identifies in his deposition as being aware of and knowing about and that their business made. And Exhibit 13 is an email from the defendant company that also Mr. Geller mentions knowing about in his deposition. Due to the pretrial order, we as the plaintiff can't call Mr. Geller to the stand. So we're asking right now that it be conditionally entered into evidence so that when Mr. Geller does get on the stand, we can question him about it after closing our case in chief.
Defense? Now, Exhibit 14 was the subject of the motion in limine, and so when I move around, it messes up the camera. One moment, please. And I understand the scenario of not being able to call this witness in your case in chief. And so I will give you certainly leeway when we come to the examination and utilization of exhibits as it may be deemed appropriate. Because as I mentioned, I reserved any ruling ultimately on number 14 in particular.
Yes, Your Honor. So we will wait to try to enter those in until appropriate. Noted.
All right. Anything further from the plaintiff in your case in chief?
No, Your Honor. At this time, the plaintiff rests.
Anything from the defense before moving to the case of the defendant?
Yes, Your Honor. We have a motion for Your Honor, if I may be heard.
All right. Outside the presence of the jury,
Yes, Your Honor.
proceed.
Your Honor, we move for a judgment as a matter of law under Rule 50. Today, the plaintiff has not produced enough evidence for a reasonable juror to find, even in the light most favorable to the plaintiff, that Chimes is liable for negligence. They haven't introduced evidence that Chimes was the company responsible for maintaining the loading dock where Mr. Gilmore was injured, or for ensuring that Mr. Gilmore was safe outside of that loading dock. Because they haven't done that, they haven't met their burden with regards to duty. But we ask for a judgment as a matter of law on that issue.
Response?
Your Honor, we have provided ample evidence that the defendant chose to make control over this area that was behind their store by forcing their employees to use it for many tasks that were outside the point of the loading dock. And as you heard from the plaintiff today, he was forced to go out there a lot, and he knew this as Chime department store loading dock. And as you heard from Kelly Daines's deposition today, the conditions there were not met to have a safe environment for those employees. So we did show that they had a duty because they were forcing their employees to go out there in order to ensure that it was safe.
I'm going to overrule the motion. We're going to take a 5-minute break before we proceed with the case in chief of defendant.
Yes, Your Honor.
Thank you, Your Honor.
All right. Matter of housekeeping. By my calculations and trying to deal with some of the matters of timing with objections and the discussions, which have been very good. Plaintiff has remaining 25 minutes. Defense has 38 minutes.
Thank you, Your Honor.
Defense ready to proceed with case in chief?
Yes, Your Honor. We call Reese Geller.
Having been previously sworn, you may proceed.
Good morning, sir. Could
Morning.
you please introduce yourself to the members of the jury?
Hello, my name is Reese Geller.
Where are you testifying from today?
I'm testifying from Waco, Texas.
Sir, what do you do for a living?
I am the owner of a department store,
What department store is that?
Chimes Department Store.
What sort of business is Chimes Department Store?
We just sell a variety of clothing or items, including clothing, shoes, tools, similar to kind of like a Macy's, maybe a little bit scaled down a little bit more.
And how long have you been the owner of Chimes Department Store?
I've been the owner since 2005, I believe.
Sir, I'd like to talk about your store. Where is it located?
My store is located in Waco, Texas.
And do you own the building that your store is located in?
I do not.
Who owns that building?
Kermit Realty Group.
Sir, do you have a lease with Kermit Realty Group?
I do.
Your Honor, permission to screen share Exhibit 11. It's been pre-admitted in evidence.
You may.
Do you see that, sir?
Yes, I do.
What is that?
This is the lease agreement that's between Lease Kermit, Kermit Realty Group and Chimes.
So let's start by talking about section 1.10, the premises. According to the lease, did you lease out the entire building or just part of it?
No, just part of it.
How did you know which part that you were leasing out?
Well, there's a map that we have attached to this lease, and it has hatches, which just shows exactly which areas we're in control of.
So let's take a look at that map from your lease. Could we get the last page of Exhibit 11? Sir, do you recognize this?
I do.
What is it?
This is a map of the area that Kermit Realty owns and where our department store Chimes is located.
There's a lot going on here. Your Honor, may we display this image without the text for demonstrative purposes? We talked about this with opposing counsel and they had no objection.
Is that accurate, counsel?
Yes, Your Honor.
You may.
Let's start by focusing on the bottom half of the map. What's the section with all the lines on it?
This is the parking lot.
Under the lease, do you rent out any part of the parking lot?
We do.
Which part is that?
Just that middle part.
So I'm going to highlight the middle third there in blue. Do you see that? Is that the area you rent?
Yes, that's exactly it.
What about to the right and left of Chimes parking lot?
No, that's not. We did not lease that area.
So moving to the top half of the map, what are those rectangles there?
This is the complex, the building complex as a whole.
Can you explain where Chimes Department Store is located?
The Chimes Department Store is located right in the middle.
So I'm going to highlight that middle box. Is that the area that you rent?
Yes, ma'am.
What's to the right and to the left of your building?
Those are other stores that neighbor our store.
What about above the building?
That's the alleyway.
Is the alleyway, sir, a part of your lease?
No, it's not.
And the loading dock we've been talking about a lot today, where exactly is that?
That's going to be located directly behind that middle square, which represents Chimes.
Mr. Beachy, could we get a mark for that loading dock? Mr. Geller, does that mark above the building accurately reflect where the loading dock is?
Yes, ma'am, it does.
Is the loading dock inside or outside of the area you rented in your lease?
It's outside the area that we rented.
So if the loading dock was outside your lease, let's take a look at whose responsibility it was. Mr. Beachy, could we get section 6.1 on the screen? And Mr. Geller, could you read that highlighted portion for the members of the jury?
Yes, ma'am. 6.1, use and regulation of common area. The term common area is defined for all purposes of this lease as that part of the shopping center intended for the common use of all tenants, including alleys, loading areas.
So according to your lease, was the loading area behind that building where Mr. Geller got hurt, was that part of your store or a common area?
That was a common area.
Then Mr. Beachy, could we have section 6.3? And Mr. Geller, could you read that portion for the members of the jury?
Yes, ma'am. 6.3, maintenance of common area. Landlord shall be responsible for the good and safe operation, management, and maintenance of the common area.
Based on that section, sir, who did you understand to be responsible for the safety of common areas like the loading area where the plaintiff got hurt?
A Kermit Realty Group.
Thank you, sir. Pass the witness.
Plaintiff,
May I proceed, Your Honor?
you may.
Mr. Geller, you're the owner of Chimes Department Store, right?
Yes, ma'am.
It's your family's company.
Yes, ma'am.
And you were already working for Chimes Department Store in 2005.
I was.
You were around when you negotiated the lease.
I was yes, ma'am, I was.
You helped your dad negotiate the lease, actually.
I did. I was involved in that negotiation.
You're also aware of an email that your father has sent to Kermit Realty Group, aren't you?
I believe so.
Would you recognize that email if I showed it to you?
Most likely.
Your Honor, permission to screen share.
Permitted.
Mr. Geller, this is an email sent from your father, right?
Yes, ma'am.
At the bottom there, it says Chimes Department Store, right?
It does.
And this was sent to Kermit Reginald,
Yes, ma'am.
the landlord.
Yes, the landlord.
Your Honor, at this time, the plaintiff moves Exhibit 13 into evidence.
Defense,
No objection.
13 is admitted.
Now, Mr. Geller, according to this email, Chimes Department Store asked Kermit if they could turn an emergency exit into a loading dock, right?
Yes, ma'am.
Right there, your father acknowledged that it was an emergency exit.
Yes,
And they wanted to remove those rails, didn't they?
they did.
The railing that was around that emergency exit.
Yes, to make it a loading dock.
Thank you, Mr. Koenig. You can take that down. Now, Mr. Geller, after your father sent this email, those rails were taken down, weren't they?
Yes, Kermit took him down.
And you also got Kermit to pave a driveway for you, didn't you?
I believe so, but I'm not too sure about that. I don't know if that was me or my father.
But Kermit did pave a driveway for you, didn't they?
I think so.
So when you requested changes to the common area, the landlord did them.
Yes,
Now, this common area that you guys keep talking about, you put a dumpster back there, didn't you?
yes, we did.
You bought that dumpster.
Yes,
You put that dumpster back there.
yes.
And you never asked Kermit Realty Group if you could put a dumpster back there, did you?
No, because we didn't believe that we were altering the property.
So when you put that dumpster back there, your employees had to go out there then.
They did, to take out the trash.
They had to go out those doors,
Yes, ma'am.
down those steps,
Yes,
and to that dumpster.
yes,
On that stairwell, we took the railings away.
yes, we did.
Mr. Geller, you're aware of an incident that happened in 2010 with one of your
Objection,
employees?
Your Honor, this is the subject of your motion in limine. Permission to be heard outside the presence of the jury.
All right, what I'm gonna do is take this constructively up and see what kind of foundation we're going to establish. So proceed, counsel, constructively.
Yes, Your Honor. And whenever that incident occurred, your company recorded a statement about it, didn't they?
Yes,
You'd recognize that statement if I showed it to you?
I would.
Your Honor, permission to screen share?
Permitted?
Mr. Gellard, this is that recorded statement from the 2010 incident.
Yes,
This recorded statement guide is made by your company,
it is.
and this was used to interview an employee, wasn't it?
It was.
An employee about an incident that happened.
Yes, ma'am.
Your Honor, at this time, we move Exhibit 14 into evidence.
Defense?
Your Honor, I still have my same objections, both to hearsay within hearsay under Rule 805, that she hasn't established a correct predicate to making this a business record, Your Honor. Additionally, under Rule 404, this is propensity evidence. She's trying to argue that because this event happened in the past, it would be more likely that the plaintiff was injured today.
May I be heard, Your Honor?
You may.
I still stand by my response to the hearsay within hearsay. Once again, all the statements made in this were made by an employee who was employed by the defendant and therefore is an opposing party statement.
Well,
Further,
wait a minute. Has it been established that that person has managerial capacity, meaning hire and fire, to make it attributable to the entity?
no, Your Honor, but under 801 D2, excuse me, Your Honor, let me go to the exact wording so we can establish that. 801 D2D was made by the party's agent or employee on a matter within the scope of that relationship while it lasted. We established that these statements were made by an employee about an incident that happened while they were working for the defendant.
Any thoughts, defense?
Your Honor, they still haven't laid an appropriate predicate. 801 D2D requires agency, requires that someone have managerial say. They haven't established that.
Your Honor, I'd just like to point out that it says agent or employee.
Very close call, but I'm gonna overrule the objection. Admit it. All right, bring the jury back, and we will constructively have considered all this up to this point in time to have been submitted to the jury. So you can proceed, counsel.
Yes, Your Honor. So, Mr. Geller, this was about an incident in 2010.
Yes, ma'am.
An employee had to go to the back of the store
Yes.
to take out the trash.
Yes, ma'am.
And as you can see here, they noticed that it was dark outside.
Yes, it was dark.
They were told that there was no light for them.
Yes.
And then they slipped as they went down the stairs, didn't they?
They did.
If we'll go to the last page of this report, Mr. Koenig, this last part on the bottom of it says, for chimes use only, to be filled out by a supervisor or manager, right?
Yes, ma'am.
And in that last question that says, are there any steps that should be taken by chimes to help prevent such injuries in the future? The manager wrote, make sure there is adequate lighting on the loading dock. Did I read that correctly?
Yes, ma'am, you did.
Thank you, Mr. Koenig. You can take that down. So after this incident, you didn't add any lights, did you?
No, ma'am.
You didn't add any railing?
No, we did not.
And then in 2015, you actually made a smoking policy, right?
Yes.
A smoking policy that employees had to go back there to smoke.
Yes, we don't want them out front.
And when you made that smoking policy, you didn't make any changes to the back area either.
No.
You didn't try to see if you could light up that area.
No, we did not.
Now, when you decided to make this area a loading dock, you didn't restrict the access, obviously, to employees that were only unloading and loading trucks.
No, it could be anybody.
And you didn't have any removable or irremovable railing, right?
No, ma'am.
And you didn't train any of your employees to go on this loading dock properly, did you?
No. We just thought they could figure it out.
We're here today because of one of your employees fell off that loading dock, right?
Yes, ma'am.
Now, that loading dock, you've been there a lot, haven't you?
I have. I've been out there.
So you've seen the condition of those stairs.
I have.
You've seen there's no railing.
Yes.
And when you found out Jordan Gilmore fell, you guys actually installed a light switch, right?
Objection, Your Honor, to subsequent remedial measures under Rule 407.
Response?
Yes, Your Honor. As we've seen today, the defense is trying to claim that they had no control over anything in that area because it was a common area. If you'll let me continue this line of questioning, you'll actually see that they were able to control the light out there by installing a switch. And so this is going towards the control over this area that the defense is claiming they had zero control over.
May I respond, Your Honor?
You may.
This is exactly the kind of evidence that's barred under Rule 407. This light switch was put inside the building after the plaintiff was injured. Now, the light switch, again, was inside the building, not outside. The defendant just testified that he had control over the inside of the building. Certainly, he would be able to put in a light switch there. The issue is who is in control over the outside of the building. The plaintiff is using this evidence as improper subsequent remedial measures, and we ask that it be excluded.
Anything further from plaintiff?
Yes, Your Honor. I would just quickly like to point out that in 407, the court may admit this to show control or the feasibility of precautionary measures. We've heard over and over again, the defendant claimed they had no control over anything out there. And we're offering this to show they did have control over the light out there, indeed.
Well, counsel, I haven't heard them deny that there was an ability for lighting. I haven't heard there being any discussion of feasibility, which is something separate from what you inquired of in fact, subsequent remedial act. And so I'm going to sustain the objection to the question that was asked.
Yes, Your Honor. Mr. Geller, according to you, you guys didn't have any control out there, right?
No.
And you heard earlier that your manager told Mr. Gilmore that there was nothing that you could do about that light.
Can you please repeat the question?
You heard Mr. Gilmore earlier say that your manager said there was nothing they could do to control that light out there.
I believe so. I heard that. Yes.
But isn't it true that you installed a light switch later?
Objection, Your Honor. This is the same question that is barred by Rule 407.
The foundation's been laid now. I'll overrule that objection.
But after Mr. Gilmore fell, you installed a light switch.
In the inside of our building, yes.
But that light switch inside your building turned on the light outside, right?
It did.
The light in the common area.
Yes.
Now, I just want to establish that after that, whenever you sent your employees out there, you didn't put up any new railings.
No.
You didn't fix the concrete.
No.
You didn't put any safety paint on the edges.
No, ma'am.
You didn't put any removable chains or anything at the drop-off.
No, we did not.
You didn't add any warnings about a sudden drop.
No, just because it was a loading zone.
And you didn't tell any of your employees this used to be an emergency exit.
I'm not sure about.
And finally, you never once asked your landlord to implement any of these safety measures either.
No, we did not.
No further questions, Your Honor.
Redirect.
Your Honor.
Proceed.
Yes, Your Honor. Sir, counsel just asked you some questions about the outside of your area. You were asked about guardrails, sir. Why were those removed?
Those guardrails were removed because we needed a loading zone. I mean, it's a department store, and that was the only way we would be able to get merchandise from the loading trucks into our store, into the storage in the back. When we originally moved, or when we were originally doing this, we couldn't get anything into our store because of those guardrails.
Sir, is it possible to operate your department store without a loading dock?
It's impossible just because of the size of some of the merchandise and the packaging it comes in. We need that kind of that wide area to get it up that ramp.
Sir, is it possible to have a loading zone with guardrails?
It's not. Again, we just want to be able to get some of that merchandise up into our store.
Mr. Geller, did you remove those guardrails yourself?
We did not. Kermit Realty Group did that.
Why did Kermit Realty remove those guardrails instead of you doing it yourself?
It was required of us by our lease to make that request to them.
So counsel asked you on cross-examination about removable guardrails. Were you allowed to put guardrails out there?
That would be something that we'd have to request from Kermit to make that change.
Thank you, sir. Pass the witness.
Anything further from this witness?
Yes, Your Honor, recross.
Very brief.
Yes, Your Honor. You were able to put a dumpster out there without Kermit's permission, right?
Yes, ma'am.
So you could have put something like a cone out there without Kermit's permission.
That I'm not too sure about.
No further questions, Your Honor.
This witness is excused. Call your next witness.
No further witnesses for the defense, Your Honor. We rest our case in chief.
All right. Any matters from plaintiff or defense before we move to closing?
Your Honor, could we take a brief 3-minute break before closings?
We will be taking a 5-minute break.
Wonderful. Okay, then at this time, there's no other matters that we have to address.
I think that by your presentation, we're all in agreement for the 5-minute break. So we will reconvene at 11:36. Thank you. All right, council, by the calculations that I have we shouldn't have any significant issue with closing. Plaintiff has remaining 16 minutes and defense has 30 minutes. Does plaintiff wish to have any time warnings?
Your Honor, Mr. Koenig, my co-counsel, can give me the time warnings.
Great. Defense?
Your Honor, we don't intend to use all of those 30 minutes, so I'm okay.
The panel appreciates that. And with that,
Your Honor,
hold on one sec. There you go. Thank you. Pardon?
the plaintiff just is asked that we reserve 2 minutes for rebuttal.
Correct.
May I-
With that, you may proceed, counsel.
Thank you, Your Honor. May it please the court. Business first and safety last. You saw today that was the mindset of the defendant that brought us all here today. That mindset of the defendant of business first, safety last led the defendant to create a hazard. They asked for an emergency exit to be turned into a loading dock. They removed any safety features that had and didn't ask that any be added. Business first, safety last led the defendant to force employees to go out onto that makeshift loading dock over and over again. And you know how they did that? They chose to put a dumpster out there to force their employees to go out there. They chose to implement a smoke break policy to force their employees to go out there. Business first, safety last led the defendant to choose not to do anything to ensure that area was safe for the employees they were forcing to go out there. And finally, with this hazardous area sitting there waiting for something bad to happen, it happened. It happened on January 23rd, 2019, when Jordan Gilmore was going out there to take a smoke break, going out to the makeshift loading dock where the defendant told him he had to go out. He went out there with his friend into the pitch black darkness because there were no lights. And all that Jordan Gilmore knew as an employee was that there was no way the defendant could control the light out there. Tough luck. So as they went out there, Jordan Gilmore's coworker held open the door to get some light in the pitch black darkness. Mr. Gilmore decided to walk down the steps, and as he walked down, there was no railing for him to hold on to. So he steadied himself by holding on to the wall and going down these dark stairs. Took his smoke break and went back up, having to hold the wall again as he walked back up. And when he got to the top, he saw that Riley was still holding that door open, still letting light out into the pitch black, still holding that door against the wind. And so Mr. Gilmore started to go around the door in order to go inside. Put his foot on that platform. And as he stepped up, his foot slipped and he began to fall back. And members of the jury, there was nothing to catch him. There was no removable chain that we see on loading docks all the time. And members of the jury, there was no railing on the stairs that he could have grabbed as he fell. There was no railing on the stairs that would have actually stopped him from trying to fit in that small space between the door and the platform. So he fell. Riley tried to help him, tried to reach out, but it was too late. And when he landed weird on that concrete driveway, that's when he destroyed his knee. And we're here today because that hazardous area the defendant created was an accident waiting to happen. After 10 years of service at Chimes Department Store, that's what Chimes did for Jordan Gilmore, was forced him to go into a dangerous area over and over again. You got to talk to Jordan Gilmore today. You got to learn about how Jordan was a simple man living in Waco, and he just wanted to take his smoke break. Now, when Jordan Gilmore started at Chimes Department 10 years ago, there was no railing there. And all he knew about that was it was a loading dock. As you saw, he saw that sign every day walking out, but there was no fire alarm when he walked out. As far as he knew, that had always been a loading dock. But as you learned today, that's not the case. The defendant turned it into a loading dock. Now, we brought a claim today, and because of that, we had a burden of proof to prove to you today. So I want to talk about what we had to prove to you today by preponderance of the evidence. Mr. Koenig, could you pull that up? First, we had to show you that there was the condition in question posed an unreasonable risk of harm. Members of the jury, you heard from Jordan Gilmore describing those stairs that were falling apart, the lack of railing, the pitch black darkness, and the sudden drop off that loading dock. And you actually saw pictures of the loading dock, the makeshift loading dock. And I want to look at those again. You saw that in that corner, when that door was open, the corner where Jordan Gilmore had to step on, there wasn't even concrete. The concrete was falling apart. These stairs were falling apart. There's a sudden drop. There's no markings anywhere to indicate anyone when they're out there in pitch black, hey, by the way, there's a drop. Or hey, by the way, there's a stair here. You also heard from Kelly Danes about the awful condition that she inspected out there. And you heard from the owner's defendant themselves that they knew there was no guardrails out there because they asked for that. And you heard the defendant admit that he saw the falling apart conditions all the time. But the defendant still chose to not only have a hazardous area, but create a risk when they sent workers out there to go up and down those steps in the dark. Next, we had to show you that the defendant knew or reasonably should have known of the danger. Members of the jury, you saw an employee incident report today made by the defendant, where an employee went out to take the trash. It was dark, was told there was nothing they could do about the lights, fell down those stairs, and you know what the manager wrote down on this report that the defendant kept? Maybe we should put some lights out there. Members of the jury, that was 9 years ago, before the incident with Jordan Gilmore, and nothing was done. You also heard from Jordan Gilmore about what the manager said to them. When Jordan Gilmore fell off, hurt themselves, and went inside, the manager said, yeah, I've been telling them we should fix those stairs, but that's it. So not only was there an official incident report, but the manager themselves admitted to telling the defendant something needed to be done. And you also heard that Jordan Gilmore complained about the lack of lighting out there when he was forced to go out there day after day. Members of the jury, not only should Chimes Department should have known, but they knew that there was a danger. The minute in 2010, when that employee fell down those stairs and hurt themselves. The third thing we had to show you by preponderance of the evidence is that Chimes Department Store failed to exercise ordinary care to protect Jordan Gilmore from danger by failing to warn him or to make the condition reasonably safe. Now, I want to talk about something that you've heard a lot from the defense today, something about a common area, something about a lack of control over it, something about how only the landlord was responsible for maintaining that. Well, members of the jury, we heard that that's not the truth, that they did not lack control in two extreme instances, actually three, if we really want to talk about it. The first, the minute the defendant asked, can that railing be taken away? Do you know what happened? That railing was taken away. The minute the defendant asked for a driveway was made back there. No control. No control at all. No control to send a quick email and request something. We saw that's not true. Secondly, members of the jury, we heard about that light switch because when Jordan Gilmore was working there for 10 years and complained about that lighting, he was told there was nothing they could do. But the minute that Jordan Gilmore was hurt, the defendant was able to control the light out there all of a sudden. And third, members of the jury, the defendant confessed to you that they put a dumpster back there. Now, I'll admit, a dumpster isn't a permanent change like taking out the railings or anything like that, but it's just putting something back there. So the defendant easily could have put a sign on the door that said sudden drop. They could have put cones where the drop-off was right there. They could have put some tape right there. They could have done that because they'd done something like that before when they put that dumpster out there. Members of the jury, I talked about the tipping of those scales. But as you can see, those scales tip much more in our favor than slightly. We have met our burden, but today we're not the only ones that had to prove a burden. The defendant brought an affirmative defense. And you heard a lot about what they had to say about that. So I want to go over what they had to prove for their affirmative defense. Members of the jury, they had to show you those same three things, but with Kermit Realty Group. And I want you to know that if they fail on any three of these and they have not met that burden, and you cannot hold Kermit liable. Now, I'm not going to go through each of these because I don't have a burden to prove them. But what I want you to focus on is the second prong. Kermit Realty Group, LLC, knew or reasonably should have known of the danger. Members of the jury, when were you told today that Kermit Realty Group used that loading dock all the time? When were you told that they sent their employees out there all the time? When were you told that Kermit Realty Group know about the conditions out there? You weren't. All those things were what the defendant knew. And because the defense failed to provide any evidence to show that Kermit Realty Group knew or should have known about this condition that the defendant saw every day, they cannot meet this burden, and you cannot find Kermit liable. Now, the last thing that we had to show, and we've already discussed this, so I'm just going to go over it really quick because you're going to see this when you see your jury charge. And that has to do with control. It talks a lot about control. And what I want you to remember is how easy it was for the defendant to send an email and get a change made. Just because they couldn't go up there with hammers and nails and fix something does not mean they did not have control over the conditions out there. All they had to do was send an email. Members of the jury, when you go to the end of your jury charge, you're going to be asked to answer some questions. So I want to go over them. Did the negligence of any of those named below approximately cause the occurrence or injury in question? Members of the jury, this has to do with those three things we had to prove. And as we showed you today, we did prove by much more than proponents of the evidence that Chimes department store was negligent. So you're going to put yes here. And when you look at this second question, I want you to remember what the defendant had to prove in order to find Kermit liable. And they couldn't prove it. So you're going to have to put no. And for Jordan Gilmore, members of the jury, Jordan Gilmore was out there doing what the defendant told him to do. You can't hold him liable for that. So you're going to put no. Thank you, Mr. Koenig. You can take that down. Business first, safety last. When the defendant knows about the conditions and knows what they can do to change those conditions. We have to make sure that businesses are keeping our employees safe. And you can do that today by finding the defendant liable.
You have 2 minutes remaining. Defend,
Closing argument, Your Honor.
proceed.
When Ms. Kazemski was speaking just now, I couldn't help but find myself nodding along to a lot of what she said. That's because you've seen again and again during this trial, there's a lot of agreement between the defense and the plaintiff. We agree that the loading area wasn't safe enough. We agree that the condition contributed to Mr. Gilmore's injuries, and we agree that the right party should be held responsible. But members of the jury, what you saw today is that just isn't Chime's department store. And you didn't just have to take my word for it because you saw the lease, the contract between Chimes and their landlord. And that says explicitly that those loading areas that we've been talking about all of today, those are common areas. And common areas are the landlord's responsibility. And so when the landlord, Kermit Realty, made choices about the loading area, even dangerous choices, ones that caused Mr. Gilmore to get hurt, those were choices that the store couldn't change. The plaintiff today had the burden of proof. They had to show you by a preponderance of the evidence that there was a duty, that Chimes breached that duty, that there was injury, and that Chimes' actions were the direct and proximate cause of that injury. And I want to focus here on the choices that Chimes couldn't change, those of the landlord and those of the plaintiff. Let's start with the landlord, because that goes to the plaintiff's first element of duty. They had to show you today that Chimes grocery store owed a duty of care to Mr. Gilmore on that loading dock and in that back alley area. The central portion of that question is control. You'll have those jury instructions to take home with you, members of the jury. The judge will instruct you that for Chimes to be liable for this action, they must have control over that area. What that means is if Chimes doesn't control that area, that loading dock, they didn't owe a duty of care there. And that makes sense. Think about it. That requirement of control, if someone doesn't control an area, how do you expect that they'd be able to change it? So say, members of the jury, that you live in an apartment building. Your landlord says, now, you can take care of your apartment that you rent. We'll take care of the pool that's outside. Even if you use that pool, even if you're the only one in your apartment complex who swims, it's still your landlord's responsibility to maintain. That doesn't change. And that's exactly what happened here. Chimes was just one tenant in a whole shopping center. They don't own the building. Their landlord did. And even though they used some part of it, even though they used that loading dock, they weren't the ones responsible for it. Members of the jury, that lease, it couldn't be clearer. Kermit Realty was in charge. The lease tells you exactly who was in control, members of the jury. I mean, we talked about it over and over again in this trial. I bet you wish we didn't have to. I mean, it's pretty boring to read a lease like this, to read about common areas, demise, premises. But after all of that, it's clear what the answer to the question of control is. It wasn't Chimes who had control over that area. It was Kermit. But that's not what the plaintiff wants you to believe. Now, it's true that there was a change to that loading dock that Chimes requested. The plaintiff talked about it all through her opening statement. She was right about that as well. But that request doesn't change anything. It doesn't show that Chimes had control. Actually, it shows the opposite. It shows that they had to ask the landlord to make a change like that. They couldn't do it themselves. They had to rely on the landlord to carry it out. Members of the jury, let's take a look, of the map on that lease. You saw this today in court. We know that Chimes oversees their parking lot. We know that Chimes oversees their department store. We also know they don't oversee those alleyways. Now, the plaintiff today in their closing argument got up here and said, well, there are all these reasons why Chimes actually has control over that area. The first reason that the plaintiff talked about in her closing argument was the dumpster. She said, members of the jury, look, the defendant put a dumpster back there. So that means that they had control of the area. That's their responsibility. But Mr. Geller told us, you can see in that lease, members of the jury, that area, that loading dock, is a common area. Everyone can use it. That doesn't mean that Chimes controls it. Anyone in that apartment complex has the ability to use that dumpster, and that makes sense. Those are businesses that are around that area. We heard that there was a department store, Chimes, in that area. We heard that there were 2 other businesses on the other side. So of course, everyone could use that dumpster. That doesn't mean that Chimes controlled the area. Well, then she told you about a light, members of the jury. She said, we know that Chimes controlled that area because later they put a light inside their store. Members of the jury, that's not in dispute today. We know that Chimes department store controls the inside of their store. Of course, they've got their business area, they've got furniture, they've got clothing. It's sort of like a Macy's, members of the jury. They have all sorts of things on the inside. They also have lights on the inside, lights that they control, lights that they can change. That's not at issue today. What's at issue today is the outside. Members of the jury, those were choices that Chimes just couldn't change. This case is pretty simple, ladies and gentlemen. The plaintiff sued the wrong person, and that makes sense. He said today that he worked at Chimes department store for 10 years. He walked under a sign that said Chimes department store every day for 10 years, over and over again. He didn't walk under a sign that said Kermit Realty Group. He has no idea that he was suing the wrong person. Well, let's talk about what he did know. And because on January 23rd, 2019, Jordan Gilmore acted unreasonably when she was outside that night. He was outside to smoke cigarettes, and he didn't open the door all the way. Instead, he tried to move around this door right here with just inches of space. He went all the way up to the edge of that staircase in the dark. Members of the jury, what's more is that he told you today that he himself jumped off of that staircase and fell to the ground. It was only after the plaintiff jumped himself, made a deliberate choice to leap off of that staircase, that he got hurt. Chimes department store didn't make him do that. The Chimes department store didn't make sure that he walked up that little portion of the stairs. A Chimes department store didn't close the door in front of him so he couldn't walk around it, and certainly didn't make him jump. We didn't make any of those choices. Those were things that we just couldn't change. Members of the jury, the judge will instruct you in a moment on the law. These are the jury instructions that you'll have with you. We're going to ask you to take a look at each one of these instructions. It asks you first, who is negligent? The first person there, that's Chime's department store. We're going to ask you to write no. And that's because Chimes didn't have control over that area. Next is Kermit, a realty group, and Jordan Gilmore. We're going to ask you to write yes for both. And because it was Kermit, a realty group, that actually had control of that area, a Kermit Realty Group that removed those guardrails, and Kermit Realty Group that should have made sure the plaintiff was safe. Members of the jury, the plaintiff herself made choices that Chimes just couldn't control. And then you'll go to a second page, ladies and gentlemen. That page is going to ask you to assign a percentage of responsibility. Because that lease made it impossible for Chimes to change the design of that outside area, we're going to ask you to write 0% for Chimes. And then we're going to ask you to split a 50-50 between the plaintiff and Kermit Realty Group. Because on January 23rd, 2019, they both made choices that Chimes couldn't change. Members of the jury, after hearing all of the evidence today, after seeing what Chimes could do and what Chimes couldn't do, we ask that you find for the defense. Thank you very much for your time.
Rebuttal for 2 minutes.
Yes, Your Honor. Members of the jury, we just heard a lot about choices. But what about choices that weren't made? It was the lack of choice that brought us here today. When the defendant refused to choose to send any simple email, just like they chose to that first time to take out that railing, they could have chosen to send a simple email anytime after that. But they didn't choose to do that. They didn't choose to ensure that that part of their store where they were sending employees was safe. We're here because the defendant chose not to keep them safe, but instead put business first and safety last. Find the defendant liable.
The case is now submitted to the jury. Very, very good job. We are going to take a 3-minute break while the scoring judges submit matters, and then we'll come back for very brief comments. right. Let's see. Boy, she keeps dropping off. Okay, there we go. Good. All right. I haven't gotten all clear yet, but let's go ahead. Who would like to start with comments? You know who I'm going to volunteer.
I've seen this movie before. Yes.
Okay, I'm happy to sort of take the lead on the comments then. Can y'all hear me?
Good.
Okay, perfect. I want to start off by saying that you guys were both exceptional. You both had a really strong grasp. I think Joy, I think you had the harder case to prove. Maybe people disagree, but I felt as though there were more facts that you had to defend against. But I think you sort of did that in stride. And tell me, is it Jackie? Is that how you pronounce your name?
It's Jack. It's hard to know that though.
No, all good. Jack, I thought that your responses to the objections that were made, which Joy, you were bringing them, and Jack, you each time sort of knew exactly where you were going to go. So it seemed as though you sort of thought through the fact that these could potentially be objectionable. And so you knew how to get them in every time. And so to sort of both of you, great job on that. For constructive sort of, it's criticism, but not really. Joy, I know you guys don't have a ton of time to sort of think through this problem before you get it. That's sort of the nature of this competition. The thing about a theme-like choice is Jack is able to easily at the end say they made a choice. And that choice is that, they didn't fix the condition. They could have sent an email, all of that. So, I don't know how much time you have between this round and next round or kind of how, if it goes forward. But as you're coming up with the theme on either side of the case, remember that it could potentially be, if your theme can be taken down very easily by the other side, you might want to sort of rethink it some more to make sure that they don't use it against you in their closing argument. Jack, for you, I would say you had a really good presence about you. Just a confidence, I think, would help a little bit more, is just coming across like you know what you're talking about, because you did know what you were talking about. And so there were moments when I can see you sort of thinking through what you were about, what was about to happen, even though when you did it, you did a great job of it. So it's not even that you didn't do a great job so much as show it less on your face. Yeah.
All right.
I'll go next, and I'll just reiterate, you guys both did a really, really nice job. They've encouraged us to say one thing that would help you for the next round. So just take all of this under the banner of you both did a really nice job and have a really nice manner of presenting. So these are designed to help you, not to criticize for a negative purpose. Ms. Kasimsri, be very, very attuned to what the judge is saying while you're arguing evidentiary issues. They're usually giving you clues to where you ought to go. And there are a few of those times when he had to redirect you for a second half of your response. And Ms. Craig is right. You got it right the second time, but far better to get it right the first time. So listen very carefully. I'll give you a few examples so you don't think I'm just spitballing here. There was the recorded statement. The objection was 404A propensity, and your response first was hearsay. There was a 702 in legal opinion invading the province of the jury objection, and you went for about 35 seconds on qualifications of the expert and the fact that you tendered him. That wasn't actually the basis of her objection. Her objection was the rest of 702. So just be very, very careful. It's hard. There's so much going on. We all know that. We've all been there. But listen, use these every bit as much as you use your mouth. And then Ms. Holden, I love splitting questions into multiple parts so you get multiple points out of the same thing, right? You didn't do this, and then there was that, and there was this, and they're really all one question. Be very careful in doing that some of the subsequent slicing the salami thinner parts aren't condescending, because there were a few of those that the choice of what those were didn't really make sense. And just sitting here as a jury was kind of like, well, yeah. And you don't ever want to lose your connection with the jury that way. But again, you guys both just did a really nice job. So congratulations.
And I'll echo what my previous jurors have said. I thought it was a really high quality round, and y'all both knew the facts and knew what you wanted to do with it. So very well done. So these are just nitpicking. And then for plaintiff, I did want to say to what Mr. Williams said, you got there eventually, because I thought one of your strongest points was after the objection where the judge sustained it against you. He said, well, that wasn't the predicate. And then you went back and you tried it again, like you listened and you adjusted and you got it in that way. So I thought that was a really strong point from you. It's like, okay, he's overruling. I think he said, his honor said that I'm overruling as to that. And so you took that, I was like, okay, so if I try it another way, I can get it in, and you did. And so when you did that, I was like, okay, great objection and great follow-up response on both sides. So I thought that was just, it made me happy on both sides. But constructively for the plaintiff, I like where you got in the end, but in your opening, a little bit more of the audio visual, a little bit more just, it wasn't quite there for me. You picked up a lot of threads later, and I thought that was beautiful, but it was just kind of a slow start to me. And I know that's hard, right? Because you don't know where the evidence will go in your opening, but I think if you had a lot of threads that you picked up in the closing, and it would have been better for me as a juror to hear some of those in the beginning so you can see it consistently throughout. And then for defendant, I thought your objections were good. The only kind of quibble I have for a number of them, you would make your objection and you'd end it like, may I be heard? You know, that's always kind of a leeway kind of point to see how far the judge will let you get. But for my purposes, you know, always it's of course you're making the objection. You demand to be heard. You're not asking to be heard. They're doing something wrong. Of course you're going to make the objection and you're going to be heard. Damn it, you're going to get that in the record even if the judge overrules you. So I can see it maybe doing the first time, but if the judge is willing to give you some leeway on that, and you can say, of course, or go ahead, then I wouldn't bring it up again. Just bulldoze through. The other side is trying to go with something, and you're going to stop them. Like I said, just a quibble, stylistic point, but great job all around.
And I will echo now for the fourth time. I really thought both of you did a wonderful job. I'm looking forward to the bar exams being made far more difficult, so I never have to see any of y'all in a courtroom. But very briefly, from the defense, one thing, and I'm an insurance defense lawyer, so you conceded in your opening, which I thought, you know, what was said, your opening was strong, but you said that comparative negligence of the plaintiff, partially responsible. We're not partially responsible. He's 100% responsible, because I just worried about the rest of this. Like, she's already conceded, you know, partial. So be careful about that. On the plaintiff, very nitpicky, but I think it gets back to the very first comments, you know, the idea of a display of confidence. And let me assure you, I think all of us will say both of you come across confident, but this is little nuances, but you would look up, and I think that's what was, you kind of look up and then, and you'd kind of look up, and that's part of the Zoom, but that's what, I mean, I'd had trials in Zoom, and, you know, so you got to be aware of that, and that's actually something that would come across. First time this competition that I've enjoyed the evidentiary banter. In the competition, you have to understand that it isn't necessarily if it's sustained or overruled, it's your argument, it's your discussion. And that was thoroughly enjoyable. One aspect of that, though, if you're not doing it constructively, and let me tell you, most of it won't be, you still want to be making a speech if you can. I mean, when you're saying, well, Judge, this is a violation of 404, you want to make, because the jury's going, 404, what is that? So, you know, that person ain't got no basis to be saying this, that, or the other. And because you want the jury to be following along with you, because that's part of advocacy. You do it too much, you'll get in trouble like I do all the time with the judge that tells me, Mr. O'Neill, just make your objection. So very, very fine job. We got the all thumbs up, so we got things done. Best of luck. Thanks for everyone's work on this. We're adjourned.
Thank you for judging, guys.
Thank you so
You
much.
guys are excellent.
Good luck,
Excited
y'all.
for y'all to be lawyers like us. You guys are gonna be great.
Yeah.
Seriously, you
Great
are.
job.
Thank you. Bye.
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 changing just go ahead and rename yourself on the Zoom meeting and see whoever the judge that's in your room for example is. That's it, I got it, let's see. Which courtroom are you in? Four? Yeah, so just Judge Pfeiffer is fine.
everybody. We'll get started here in a minute. Lori, if you're talking to me, I can't hear you. You're muted. Ms. Forster, how are you?
Doing well, Your Honor. How are you?
Good. You don't have to call me that. Okay, I'll put my phone number in the chat once we get plaintiff's counsel in here.
Sounds good.
Great. Just waiting on one more. We got second chair for plaintiffs here, and then we just need a first chair, and then we're ready to go. All right, there they are. All right, so I think we've got everybody. I'll put my phone number in the chat. There's my phone number in case we get disconnected. Y'all can text me. And then we can go ahead and get started with pretrial. Ms. Lori, if you want to turn your camera off at your leisure.
Your Honor, could you just give us a moment to set up very quickly?
Absolutely not. No, I can't. Yeah, take your time.
Thank you, Your Honor.
Mm-hmm. You just let me know when you're ready and we'll start doing pretrial. Nope. Come back. You with us, Miss Holden? Okay, they're back. Waiting on your second chair to rejoin. Okay, looks like he's joined twice.
Yes, Your Honor, for technology purposes, we're both in the Zoom twice.
Okay, sounds fine. Okie dokie. Okay, anything further? You need any more time to set up?
No, Your Honor, we're ready to proceed.
Awesome. Okay, so we'll do 5 minutes apiece for pretrial. I'm just going to keep a 10-minute clock running for that. I'm assuming that we're not going to take the entire 10 minutes, but plaintiff, whenever you're ready with your
Yes.
initial pretrial stuff.
Yes, Your Honor. Permission to make appearances for the record.
Absolutely.
Good afternoon. My name is Joy Holden, and I'm joined along with my second chair, Nicholas Beachy. Today, we represent the plaintiff in today's action, Jordan Gilmore. We have several housekeeping matters and a motion in limine, but we'll turn to the defense for appearances as well.
Yeah. Whenever you're ready, defense.
Good afternoon, Your Honor. My name is Jenna Forster. I'm here today with my co-counsel, Cheyenne Smith. And together we represent the defendant, Chimes Department Store.
Very good. All right, let's hear your motions, or your pretrial matters, however, whatever order you want to do them in.
Yes, Your Honor. We were able to meet and confer with defense counsel, and we've reached several stipulations today.
Sounds good.
We've stipulated to pre-admitting exhibits 1 through 7, 16 through 21,
okay,
and 31 through 35.
Okie dokie.
Secondly, Your Honor, we expect that both parties will be reading expert depositions onto the record. We were able to stipulate that both experts satisfy the requirements of Rule 702, and we therefore won't be laying expert foundation through those depositions.
Sounds good.
Your Honor, we've also stipulated to exclude any reference to a proposed OSHA rulemaking.
Okay.
And finally, Your Honor, the defense has agreed to stipulate to the feasibility and control of putting up a light switch at the defendant's department store. By way of background, this is a negligence case in which my client is alleging that the defendant negligently maintained an outside dock area with no light, no guardrails, and faulty stairs. The defendant today has agreed to stipulate that they could have installed a light, but chose not to.
Good deal. Your motion? Do you have a motion to eliminate?
No, Your Honor. Actually, with those stipulations, we have no motion.
Okay, great. Okay, defense, any pretrial matters that we need to take up?
Yes, Your Honor. A note or two about housekeeping and then a couple of substantive matters.
Okay.
The housekeeping note is, since I've never had the pleasure of appearing in your Zoom courtroom before, when we are intending to offer exhibits, can we share them on the screen constructively outside the view of the jury, or would you prefer that we not share them at all until they've been entered into evidence?
That's the latter. Yeah, but I will also say, insofar as you've pre-admitted exhibits, please don't ask me to publish them. Just go ahead and publish them.
Understood. And on that note, does that mean we can use those pre-admitted exhibits during opening statements as well?
Absolutely. Absolutely.
Excellent. Just a couple substantive notes, additions to Ms. Holden's, to the stipulations that Ms. Holden mentioned. One is that note about the light switch inside the building. We have agreed that we are not disputing control or feasibility, and in exchange, Ms. Holden has agreed that unless we dispute those things, the testimony that the defendant added a light switch inside the building after the accident is barred by Rule 407 against subsequent remedial measures.
Okay.
Further, both parties have agreed today to stipulate that the height of the landing dock that the plaintiff, Ms. Gilmore, fell off, that the height of that dock is 34 inches.
Okay.
That's all from from Chimes, Your Honor, and we're ready to proceed to opening statements.
Excellent. Okay. Let me get the time reset and just to let you know how I'm going to do this. I'll be keeping time. I'll stop it, of course, for objections. After each time that you speak, I'll let you know how much time you have left. I'll even let you know how much time you have at the very end of the round. Once we get down to 5 minutes, I'll give you hand signals, 5, 4, 3, 2, 1, so on and so forth. Here's 30 seconds. Here's 15 seconds. Once we get down to 10 seconds, I'll, count you down with the fingers. Okay. Sound good?
Understood.
All righty. I'll now recognize plaintiff for opening statement whenever you're ready.
Yes, Your Honor.
And Your Honor, is it all right with you if I turn my camera off during Ms. Holden's opening, just so I don't cloud up the Zoom room?
Yeah, absolutely. Your choice.
Thank you.
Apologies, Your Honor. My microphone just left me. Just a moment.
Yeah, take your time. I'll start timing when you start talking.
May I proceed, Your Honor?
You may.
The defendant made dangerous demands. Members of the jury, what if I told you to walk up a set of stairs with a sharp drop off? At night, outside, in the wind, in the dark, without a light and without anything to hold on to? You probably wouldn't do it. You'd probably tell me that sounds like a bad idea. That sounds pretty dangerous. What if I was your boss? What if I told you that you had to? Today, you're going to meet a Jordan Gilmore. You'll hear that is exactly what happened to her. She's here today because of the dangerous demands that her employer, the Chimes department store, made. See, it all starts back in 2005, when Chimes department store rented a new building right here in Waco. And that building has a back dock that looks something like this. But that's not what it looked like when the defendant moved in. Today, you're going to learn that there used to be guardrails on that staircase. But when the defendant moved in, they demanded that their landlord tear them off. Members of the jury, that's not just a dangerous demand. You're going to hear that's against the law. A few years later, Jordan Gilmore started working as a cashier in that store. And while she was working in that job, she fell off those dangerous stairs that the defendant maintained. I actually want to introduce you to Miss Gilmore. In fact, Miss Gilmore, could you turn on your camera for the members of the jury? This is Jordan Gilmore. And she worked as a cashier at Chimes, a department store, for over 10 years. And for over a decade, she did everything her employer asked her to do. Thank you, Ms. Gilmore. You can turn your video off. One of those things that the defendant demanded was that if she wanted to take a break, she had to go down a dangerous stairs to do it. These dangerous stairs. You'll hear today that company policy required it. It didn't matter if it was dark or if it was windy or late at night. That's where they had to go. And you'll see that when the defendant corporation demanded employees take the stairs to take a break, they knew that it was dangerous. You see, the law requires stairs like these to have a guardrail to keep people from falling off. So that on January 23rd, 2019, when Ms. Gilmore was out on those stairs for a break, and it was dark, and it was windy, she lost her balance. And she fell. And with nothing to stop her fall, nothing to grab onto, she landed hard. She got hurt. She got hurt because of the defendant's dangerous demands. And that's why Ms. Gilmore is suing the Chimes department store for negligence. And as the plaintiff, it's our job to prove that it's more likely than not The defendant corporation knew that the break area was dangerous, failed to protect its employees from that danger, and that their failure was the direct and proximate cause of Ms. Gilmore's injuries. Members of the jury, today we'll meet that burden by asking you to focus on 3 points. First, what the defendant corporation demanded of their landlord. Second, what they demanded of their employees. And third, how little they demanded of themselves. Let's walk through those now, ladies and gentlemen, starting with the first. What the defendant corporation demanded of that landlord. Because you'll hear today that there used to be a guardrail all along those stairs and along the landing. But when the defendant moved in, they removed it. Ladies and gentlemen, you might hear today the defendant claim that they removed that guardrail to make sure that the back alley was a loading dock. But we'll show you that they could have used that back area as a loading dock, but still kept employees safe. And that brings me to my second point, what the defendant demanded of their employees. You'll hear today that those employees had to use those stairs every single day. You'll hear from Ms. Gilmore. We expect that she'll testify that her boss made her use those stairs every time she needed to throw trash out, every time she needed to take a break. It didn't matter if it was dark or windy or late at night. She'll tell you that her boss knew that this was dangerous. But the defendant never fixed that danger. Members of the jury, and that brings us to our third and final point. Even when the defendant made dangerous demands of their landlord and their employees, they didn't demand anything from themselves. You'll hear that at the break area, that light doesn't work. The employees at Chime Store, they can't turn on that light. So at night, it gets dark and it's hard to see. You'll hear that employees complained about how dark it was, that the defendant knew removing a guardrail in the dark with a sudden drop to the ground could create a safety hazard. But they did it anyway. And they didn't demand any diligence for themselves. Members of the jury, at the end of today's trial, I'll speak with you again. I'll remind you of the dangerous demands that the defendant made to remove those guardrails, to make their employees use those stairs at night, to ignore those employee complaints. I'll come before you and I'll just ask you to make a reasonable request. That's to find the defendant liable. Thank you.
Okay, 47:14 remaining. Let me get your time reset. Okay, whenever you start talking, I'll start timing.
Sure, thank you. The steps were safe if the employees were safe. Today, you're going to hear about Chime's department store. You're going to hear about the loading dock located at the back of that store. You're going to hear that on January 23rd, 2019, it's true that Jordan Gilmore fell off that loading dock and that she got hurt. Folks, the evidence will show that that loading dock wasn't dangerous as long as you're being careful. The evidence will show those steps were safe if the employees were safe. Now, you're going to hear a lot about Chimes department store today. In fact, you'll meet its owner, Reese Geller. Ms. Geller is going to come before you, and she's going to tell you that Chimes is it's a local business, and it's a family business. She'll tell you she is the third generation of Gellers to own that store. Her grandparents started it. Her parents took over. And 10 years ago, she became the Geller in charge. And she'll tell you that back in 2005, business at Chimes was good. So good that they were looking to expand, to look for a new place for their business. And they found that place right here in town, downtown on Bosque Avenue. She'll tell you that they signed the lease, they set up shop, and they realized they would need a modification. So you're going to hear today, every department store needs a loading dock, a place to offload merchandise. You'll hear that that store, when they moved in, didn't have one. So they made some requests to their landlord. They requested to have that railing on that back loading dock removed. And they requested to have a path paved from that dock out to the road so that trucks could drive up to it. You will hear that this loading dock looked just like this. No railing for 14 years. 14 years. And employees were using that dock, using this area to take out trash, using this area for their smoke breaks, day after day after day. You'll hear that for 10 years, the plaintiff herself, Ms. Gilmore, used those back steps almost every single shift that she worked. You'll hear that she never had any problems on those steps until January 23rd, 2019. Folks, you'll hear what was different about that day. You'll hear that nothing about the stairs was different. Nothing about the lighting was different. What was different was Ms. Gilmore. You'll hear that that day, she just wasn't being careful. She wasn't being safe. What you're going to hear is that around 7 p.m. that day, Ms. Gilmore goes outside with a coworker. She walks down the steps. She stands out there and smokes a cigarette, throws the butt in the dumpster, and she goes to walk back up those steps. Now, she's been there before. She knows what it looks like. She knows how dark it would be out there, but she didn't bring a light. And as she's walking up those steps, she sees what you see here. She's on the other side, of course, at the bottom of the steps. But she sees this door extending out into the walkway, blocking her path. And at that point, she's got some choices to make. She can choose to push that door closed. She can choose to pull that door open. Or she can choose to try to squeeze past it. And what you will hear is that 12-inch section between the end of that door and the edge of that dock. Of those choices she had, you'll hear she picked the most dangerous one. She didn't push that door closed. She didn't pull it open. She just tried to make it around that door. You'll hear when she tried to do that, she fell. And she got hurt. The evidence will show that she didn't get hurt because those steps were dangerous. The evidence will show those steps were safe, as long as the employees were safe. Now, this is a negligence case. Ms. Gilmore is bringing a negligence claim against her former employer, against Chimes department stores. What that means is Ms. Gilmore, the plaintiff, has a few things that they've got to prove. They have to prove to you today, number one, that there was an unreasonable risk of harm. Number two, that Chimes knew or should have known about that risk. And number three, that Chimes failed to use ordinary care to protect their employees. they're not going to be able to prove that to you today, because the evidence will show the steps were safe if the employees were safe. Ms. Geller's going to come before you, and she's going to tell you why those steps, why that loading dock looked that way to begin with. She'll tell you, you can't have a department store without a loading dock. Can't do it. And she'll tell you, you can't have a loading dock with a rail. And that doesn't make any sense either. And she'll tell you, it's not that there wasn't any light out there. It's not that she was sending employees into the pitch dark. She'll tell you when you open the doors, there was light that came out from the building. She'll tell you that in the 14 years that dock looked exactly like that, not a single person came to her to tell her that there was an issue with that lighting. You'll hear, not only did people not tell her there were any issues, someone affirmatively told her there were no issues. You're going to hear deposition testimony from an OSHA inspector. OSHA is the federal agency that's in charge of workplace safety. You'll hear that this workplace was inspected by OSHA just a year before Ms. Gilmore's injury. You'll hear that the result of that inspection, a clean bill of health. Even OSHA will tell you those steps were safe. There's someone else whose actions we're going to ask you to consider today. Now, this is hard because what happened to Jordan Gilmore is awful. And we're not going to try to minimize that at all. But folks, what you already know, and what I ask you to carry with you into this case, is that everyone's got to take responsibility for their own actions. And what you will see is that that day on that dock, Ms. Gilmore made a dangerous decision. She had 3 choices. She chose the most dangerous one. At the end of this case, I will come before you again. I will remind you of the evidence. I will remind you that it shows that those steps are safe as long as the employees are safe. And I will ask you to find Chimes not liable. Thank you.
Okay, 46:30 remaining. Reset your clock real quick, plaintiff. Okay, 47:14 remaining. You can call your first witness.
Thank you, Your Honor. We call Jordan Gilmore. May I inquire? Good afternoon, ma'am. Could you please introduce yourself to the members of the jury?
Jordan Gilmore.
Ma'am, why are you testifying today?
I had a fall a while back.
Where'd you fall?
I fell at my work, Chimes department store.
What date did you fall at Chimes department store?
It was January 23rd, 2019.
All right, I want to take a step back, ma'am. I want to hear a little bit more about you. Where are you calling in from today?
I'm calling from here in Waco, Texas.
Do you live in Waco, ma'am?
I do.
And do you work in Waco?
Well, I'm unemployed now, but I did work here in Waco.
I'd like to talk a little bit about your former workplace, a Chimes department store. What sort of store is it?
It's kind of just like a small town department store. We've got a little bit of everything.
What did you do there?
I was the cashier.
How long did you work as a cashier, ma'am?
I worked there for about 10 years.
I want to focus your attention now on January 23rd, 2019. Were you working that day?
I was.
Do you remember what time your shift started?
Yeah, it started at 12.
And how long were you scheduled to work that day?
I was scheduled to work until closing at 8 p.m.
Did you take a break?
I did.
When?
Around 7 p.m.,
Where exactly did you take your break, ma'am?
I went to the back of the store out back.
Could you pull up Exhibit 19, Mr. Beachy, and screen share it for the members of the jury? Your Honor, this is already in evidence. What is this, ma'am?
This is the loading dock area where I went to take my break.
Looking at this photo, it's daylight here. When you went to take your break at 7 p.m., was it this light out?
No, it had already gotten pitch black out.
Does the building have lights outside?
No,
Ma'am, what do you mean the building doesn't have any lights outside?
well, it has a light, but it wasn't on because we couldn't turn the light on.
So did you have access to that light switch?
No,
Did you ever tell your boss that you couldn't turn that light on?
I did. I had complained about the light a couple times, but we never were able to turn it on.
Did they ever fix that light?
No,
Did the defendant ever install another light?
no,
So how well could you see on those stairs in the break area at nighttime?
not very well. It was, like I said, pitch black out. Another employee held the door open a bit, so there was a little bit of light, but not much.
What about a guardrail? Is there a guardrail on the loading dock?
No,
What about on the stairs leading up to the loading dock? Is there a guardrail there?
no.
Well, if there was no light, no guardrail, ma'am, why did you decide to take a break there?
That's where we had to take our breaks.
What do you mean you had to take your breaks there?
Our manager had told us that if we wanted to take a break, it had to be out back instead of out front.
Your Honor, I'm showing the witness Exhibit 1. This has been pre-admitted. Ma'am, what am I showing you here?
This is the letter we got from our manager telling us to smoke out back or to take breaks out back.
Ms. Gilmore, could you read the highlighted sections?
Yeah, the owner does not want any employees taking smoke breaks in front of the store. If you're going to smoke, you need to smoke out behind the store where our dumpster is. That is the only place you should take smoke breaks on the premises.
After your boss sent you this, ma'am, where did you take your breaks?
Out back, behind the store.
So I want to break down exactly what happened when you followed your boss's instructions. You go to the break area, it's dark. What do?
Well, I walked down the stairs to the bottom, to the ground, and I took my break.
Were you there alone?
No, one of my coworkers had gone out with me, and she was kind of just standing in the doorway.
After your break was over, ma'am, did you head back inside?
I did. I went back up the stairs. Yeah, I tried going back up the stairs.
Could you tell us what happened when you tried to go back up the stairs?
Well, as I walked up the stairs, I tried to get back around the door because it was opened out towards me, and so I had to scoot around, but my foot slipped and I could feel myself falling, and I was trying to land on both feet when I knew I could fall, and that's when I fell off the loading dock.
Ma'am, when you slipped and lost your balance, was there anything for you to grab onto?
No,
Was there anything preventing you from falling off that edge?
no,
Were you injured, ma'am?
yes,
Did you tell your boss what happened to you?
I did.
When you told your boss you fell off the stairs, did they say they were surprised?
No, she
Did they
said
say that this was the first time they thought about this issue?
no.
What did they tell you?
She said that they probably should have fixed those steps a long time ago, and that they had talked about it a few times, but they always had bigger things to fix.
Thank you, ma'am. Your Honor, pass the witness.
Okay, 40:36 remaining. Give me 1 second to reset your clock. You've got 46:30. Whenever you start, Ms. Forster, I'll start timing.
Good afternoon, Ms. Gilmore. You worked at Chimes department store for 10 years, right?
Yes,
During the 10 years that you worked there, the dumpster was always located next to the loading dock, right?
I believe so, yes.
So during the 10 years that you worked there, you were required to throw trash in that dumpster.
Yes,
You threw trash in that dumpster at least once every shift, right?
probably, yeah.
You also smoked the whole time that you worked at Chimes.
Yeah,
You smoked a pack a day.
that was average, I guess. Yeah,
So if on average you smoked a pack a day, you took at least one smoke break per shift while you worked at Chimes. Is that right?
most of the time. Sometimes I would just do it on my way to work, but yeah, usually.
Most of the time, you took at least one smoke break during your shifts.
Yeah,
Now, between your smoke breaks and throwing out trash, you'd estimate you were out on that loading dock about 20 times per week.
around there, yeah.
This might sound like a silly question, Ms. Gilmore, but there are 52 weeks in a year, right?
Yes,
So by my math, 52 times 20 times a week, that works out to about 1,000 times per year. Does that sound right?
I would assume so.
I won't make you do the math, but it sounds right, doesn't it?
Yeah,
So about 1,000 times per year over 10 years means that you use those steps about 10,000 times before January 23rd. Is that right?
sounds like it, yeah.
And in those 10,000 times, you'd never fallen off those steps before.
No,
I want to talk about what that area looked like. Now, you know there was no railing on those steps.
yeah,
There was no railing the very first time you used those steps.
no, probably not.
No railing any of the 10,000 times you used those steps.
No,
There was no railing on January 23rd.
no,
Now, there was an outdoor light that didn't work, right?
correct. We weren't able to turn it on.
But that was true even the first time you used those steps.
Yes, correct.
It's true every one of those 10,000 times.
Well, I mean, usually it was often during the day too, so we didn't need it, but yeah, whenever it was at night, we were never able to turn it on.
It was true every time you went out there at night.
Yeah,
And it was true on January 23rd.
yes.
Now, over the course of the 10 years that you worked for Chimes, you never complained to anyone about the lack of railing.
Well, I complained about the lights because if we had lights, I probably wouldn't need a railing. It would be easier to see at least.
You never complained about the lack of railing.
No, just the lights.
You never complained about the state of the stairs.
No,
You never made any complaints about the door.
no,
Now, we've heard that the light outside didn't work, but you'd agree with me, you own an iPhone, right?
I do.
You know it's got a flashlight function on it.
Yeah, but I didn't bring it out there that night. We were never told to like bring our phones out on our breaks or anything.
Just to check, that was a yes to my question. You know your phone has a flashlight function.
Yeah,
And like you said, you didn't bring it with you that night.
no, we had never been told to do that or anything.
Sure, you didn't bring it with you that night.
No.
Now, you told us a few moments ago that you fell when you were walking around the door at the top of that landing. Is that right?
Yes.
I want to talk about the choices you had when you were walking up those stairs. And I'm going to show you Exhibit 18. This is a photo of those stairs with the door closed, right?
Yes.
So as you were walking up those stairs, this isn't what that looked like, right?
Correct.
When you were walking up those stairs, the door was extending out across the walkway.
Yes.
Now you could have pushed the door closed, like in this photo.
Well, my coworker had been standing there holding the door open. So she was standing right there.
You could have asked that coworker to pull that door closed, couldn't you?
I could have.
Let's talk about something else you could have done. I'm going to show you Exhibit 6. This is a photo of the door open, right?
Correct.
When you got up to the top of those stairs, you could have pulled that door open, right?
Yeah. Like I said, my coworker was holding on to it so the wind didn't catch it.
You could have pulled it open.
Yeah.
Could have asked your coworker to push it open.
Yeah.
I'm going to show you Exhibit 3. The last of those choices you had was to leave that door where it was and try to go around it. Is that right?
Correct.
That's the option you chose.
Yeah.
It was going around that door. That's when you fell, isn't it?
Yeah, that's where I fell off the edge.
Thank you. Nothing further.
Redirect, Your Honor?
Yeah, hold on one second. 39, 37 remaining. Let me get your time reset before we do that. 39, 37. Okay. And you've got 40, 36. Start telling when you start talking.
Ma'am, on cross-examination, Ms. Forster asked you some questions about lights outside. She asked you if you ever brought your iPhone outside to shine a light on those stairs. Did the defendant ever tell you that it was your job to provide lighting?
No.
Ma'am, I want to talk a little more about the lighting outside. How dark was it when you were outside at night?
Well, that night it was pitch black out. There was just a little bit of light coming from inside. That's that my coworker was standing in the door, so it was also kind of blocking the light, but
Did the defendant ever turn on the light outside?
no.
Did you ever complain to the defendant about the lack of lights outside?
I did. I had complained to them a couple times about not having any lights out there.
Did they fix the issue?
No.
Thank you, ma'am. No further questions for this witness.
39, 23 remaining. You gonna call another witness, plaintiff?
Yes, Your Honor. We would like to call a witness by deposition now. Permission to have my co-counsel read portions of the deposition onto the record, and for convenience of court and counsel, maybe screen share parts of the document for reading.
That's up to defendant. You have any objection to that? I guess let's clarify. When you say you're going to share parts of it, you're just going to share the excerpts you're reading, or you're going to share the whole image of the deposition?
Excerpts we're reading, Your Honor, will be highlighted on the screen.
Any objection to that, defendant?
No objection.
Okay, if there's no objection, then we shall do that. 3923, whenever you start.
Sure. I'm going to start with page 2, line 6. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
Page 3, lines 13 through 21. I noticed that your CV lists you as a PE. What's that?
It stands for professional engineer.
What do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the Fundamentals of Engineering exam, which I did. Then you work as an engineer for 4 years before you take the professional engineering exam. So I took that as well and I passed.
Page 8, line 16. Okay. What opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
Page 9, line 9. Why are those significant in this case?
These are general provisions that require an employer and/or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards. So fairly clearly, the defendant violated these requirements under both the IBC and the OSHA regulations.
Page 11, line 24. What's next?
Next, we move to OSHA 1910.23D1 and 1910.24H and IBC 1009.11.
Why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there was no guardrail on these stairs on the exposed side, which is obviously dangerous.
Thank you. Your Honor, we have no further portions of this deposition to read. Pass the witness.
3640. You're going to be reading portions of this deposition as well, defendant? Or defense
Yes,
counsel?
Your Honor. Can I do that at this time?
Yeah, let me reset your time. So you've got 39, 37. All right, and whenever you start talking, I will start timing. I'm going to stop saying that, sorry.
No worries at all. Page 14, lines 12 through 21. You would agree, though, that this area was used by Chimes as a loading dock at times?
Yes, at times.
And a guardrail around that loading dock would certainly inhibit Chimes' ability to use it as a loading dock.
Yes, it would make it difficult.
Can you point to any specific regulations or codes related to how or if employers or others must place guardrails around loading docks?
No, I'm not aware of anything like that.
Thank you. Nothing further.
Okay, 3855 remaining. Plaintiff, anything further before you rest your case?
No, Your Honor. With that, we rest our case in chief. We ask for a brief 5-minute recess before the defendant's case.
That's fine. My jury members or fellow judges, whatever you want to call yourselves, if you leave the room, if you do me a favor, turn your camera on. That way we're aware that you're gone. And then when you return, you can turn your camera off. So we'll be back at, let's just go ahead and call it 3:50.
Thank you, Your Honor.
Mhm. All right, I think I've got all my jurors back. Gonna ask that, and if I don't hear anything, I'm assuming y'all are all here. There's no cameras on, so going once, going twice. I assume they're all here. Okay. So starting with defendant's case, or yeah, defense case in chief. We're gonna do 3855 remaining. Whenever you're ready, defense.
Defense calls Reese Geller.
Thomas Geller, you've been previously sworn. Whenever you start.
Good afternoon, Ms. Geller.
Good afternoon.
Can you tell us just a little bit about yourself?
Sure. So my name is Reese Geller. I am the owner of Chimes Department Store. I live in Waco. I went to Baylor University. Go Bears. I am married and we have 3 children.
You said you're the owner of Chimes Department Store. Tell us a little bit about the store.
So it's a department store. It's locally owned, Waco based. It's kind of like a JCPenney or a Macy's.
How did you become the owner of Chimes?
So as I said, it's locally owned. It's actually a family store. So my grandparents founded it. And then after they retired, my dad ran the store, and whenever he thought that I was ready to take over, I became the owner.
How long have you been the owner now?
For about 10 years.
Where is the Chimes store located?
We're on Bosque Avenue here in Waco.
Can you describe just the general layout of that location?
Yeah, so we're located in a strip mall. We're in the middle, so we're next to some other stores. We have our front entrance and the inside, and then we have a back entrance exit.
That back entrance exit, what's back there?
So we have the loading dock, and then we have the stairs, and it's basically just kind of concrete parking lot.
Show you exhibit 19. Is this that back area?
That is it, correct.
Now I see a raised platform in the center. Is that the loading dock?
Yes, that's the loading dock.
Now for the members of the jury, what is a loading dock?
So a loading dock's a pretty typical thing you'll see at most major stores. So we get products shipped to our store, and to make it easier to unload, it allows the big truck to come and back up, and we could just easily grab stuff off the dock instead of having to climb up and down the whole time.
What else is this area used for besides as a loading dock?
So we take the trash out here, and it's used for employees to come take breaks.
Thank you, Ms. Smith. Was there ever a railing around that dock?
At one point.
When was it removed?
Pretty close to whenever we moved to this location, so around 2005.
Why was it removed?
So that way this area can be used as a loading dock.
Let me ask you this. Can you run a department store without a loading dock?
Not really.
Can you have a loading dock that has a railing around it?
Definitely not.
Do employees use this area pretty often?
Yeah, they come out a couple of times a day, probably.
How do you expect your employees to act when they're out on this loading dock?
I just expect them to act as any other person would if they're in an area, just to be aware of their surroundings and be safe.
Are employees ever back there at night?
Yes, they are sometimes.
What is the lighting situation like?
So it's 2 double doors, as you saw, so it opens pretty wide, and so the light from the store gets flooded out to the outside.
You said the door opens pretty wide. How wide does that door open specifically?
It opens completely flat to the door.
I want to move on and ask you if you were aware of any issues with this loading dock before January 23rd. How often do you receive deliveries there?
At least every day.
So if you receive deliveries every day and employees also use it to take out trash and for breaks, how often would you guess employees go back there?
I'd say it's a high use area.
How long before January 2019 had you been using that area just like that?
Like I said, we took the rails off around 2005, so 14 years.
Have you been in this courtroom for all of the trial so far today?
Yes, I have been.
Did you hear Ms. Gilmore say that she'd estimate she walked up and down those steps 10,000 times?
I did hear that.
Between Ms. Gilmore's 10,000 times and all the other employees over those 14 years, how many other incidents, accidents did you have on that loading dock before January 2019?
Only once.
Is your store inspected regularly by OSHA for safety issues?
It is.
When was the last inspection that you had before January 2019?
It was in 2018.
This back area in the loading dock, did it look the same in 2018 as in 2019?
Yes, it did.
And at that 2018 inspection, did that OSHA inspector give you any citations?
We did not receive any citations.
Were you given notice of anything you needed to change about the conditions?
No, we were not.
In the 10 years that Ms. Gilmore worked for you, did she ever once come to you with any concerns about that loading dock?
She did not.
Thank you, Ms. Geller. Pass the witness.
3214 remaining. And then 3640 remaining for plaintiff's counsel whenever you start.
Yes, Your Honor, cross-examination.
Mm-hmm.
Good afternoon, ma'am.
Good afternoon.
Now, your lawyer today has told us that if those stairs were safe, as long as the employees were safe. Did you hear that?
Yes.
So I'd like to talk about your company's safety.
Okay.
Your company has no safety policy for the use of that back dock, right?
Not like a written policy now.
You don't have an oral policy either.
Well, we just instruct our employees to stay safe and that if they have any issues to come let us know.
And ma'am, you don't train your employees about how to use that dock safely, do you?
No.
You don't look for safety issues yourself, do you?
No, but as I said, our employees are out there regularly, so they know to tell us something if something happens.
I'm not asking about what your employees do. I'm asking about what you do. And you don't do any inspections of your property, do you?
No.
In fact, when we asked you before today's trial why you don't do any inspections, you said, and I quote here, "We don't consider ourselves a safety company." Did I get that right?
That is correct.
So I want to talk now about those stairs you were talking about on direct examination. They go right into your store, right?
Yes.
Not anyone else's store.
Correct, our store.
So your employees, that's where you tell them to take out the trash.
Yes.
You've got a dumpster back there, right?
Yes.
You require your employees to take out the trash right there, right?
In the dumpster, yes.
After every shift.
Yes.
Those shifts usually end at 8 p.m. Isn't that right, ma'am?
Yes, that's when the store closes.
You know that it could be dark outside when you tell them to take out that trash, right?
Yes,
That's where you tell them to take smoke breaks, right?
correct.
And ma'am, you know that Ms. Gilmore was taking a smoke break the night she was injured?
She was, yes.
And those back stairs, those were exactly where she was supposed to be, right?
Yes,
Because it's your policy that when employees need to take a break, they're required to use those back stairs.
they are.
It's your policy that when employees are going to take a break, they're required to use those back stairs even at night, right?
Yes.
So let's talk about what sorts of conditions you were sending them out to. You know that there's one light by the back stairs, right?
Yes.
You know that that light, it didn't work.
Yes.
Your employees couldn't turn that light on even if they wanted to, right?
Yes.
Ma'am, you had the power to do something about that.
Yeah.
You had the power to fix that light.
Yes.
You chose not to fix that light.
Yeah.
Now, on cross-examination, Ms. Forrester asked Ms. Gilmore about a cell phone. Do you remember hearing that?
I do.
She said, ma'am, why didn't you bring out your iPhone to shine a light on those stairs? Do you remember hearing that?
I did hear that.
Ma'am, you don't require your employees to bring their personal iPhones outside, do you?
No.
You don't require your employees to use that iPhone to shine light on those stairs at your property, do you?
No, I don't require that.
So let's talk about another condition that you sent your employees out to. Ma'am, you also removed the guardrail from the outside of that dock, right?
We did.
Mr. Beachy, could we get Exhibit 19 up, Your Honor? This is already in evidence. And could you draw for us a guardrail so that the jury can visualize what that would have looked like? Ma'am, this is about what a guardrail looked like, right?
Yes.
It's what the guardrail looked like before you took it down, right?
Yeah.
Now, on direct examination, I wrote something down so I could get it just right. You made a distinction between the loading dock and the stairs. Isn't that right?
Yes.
Those are two separate areas, right?
I mean, more or less.
In 2005, you demanded that your landlord remove that guardrail, right?
Yes.
Mr. Beachy, could you erase that guardrail from the landing, please? Ma'am, you could have just asked them to remove that guardrail from the landing, right?
We could have.
But you had them remove it from the stairs as well, didn't you?
We did.
You demanded that your landlord remove that guardrail from the stairs, even though you knew that your employees worked at night.
Yes.
Even though you knew that your employees were required to use those stairs.
Yes.
Even though you knew that if an employee had to use those stairs at night, they couldn't turn on the only light there, right?
Well, I mean, there was still the light from the inside, but yes.
I'm not talking about the light from the inside, ma'am. I'm talking about the light from the outside. You agree with me that it wasn't working, right?
Yes.
And that you knew in January of 2019 that it wasn't working, right?
Yes.
Now, on direct examination, you said, ma'am, that you removed the railing from that stairway and that landing to make a loading dock, right?
Correct.
So let's take a look at if that was actually necessary. Now, this is a fair picture of what it looks like when people are using this loading dock, right?
It's one example, yes.
Mr. Beachy, could you draw a guardrail there? Ma'am, you agree that a guardrail there wouldn't stop those people from using the loading dock, would it?
Not in this picture.
Because you said earlier that there's a distinction between the loading dock and the stairs. Isn't that right?
In this instance, yes.
The truth is, ma'am, you knew that without a light or a guardrail, those back stairs weren't safe.
I'm not sure if I could totally agree with that.
Well, you knew that employees had been injured on that loading dock before, right?
Only once, but yes, it did happen.
Your Honor, I'm showing the witness exhibit 14. You recognize this, ma'am?
Yes, I do.
This came from your company, right?
Correct.
This is a statement from a former employee who said that they were hurt on those stairs, right?
Your Honor, I'm sorry, Your Honor, I'll just note this is not in evidence, and I
Yeah,
believe
we had talked about that, counsel. Remember what we talked about during pretrial? Is that admitted yet?
No, Your Honor, I'm simply laying the foundation that this witness
All right.
knows
So,
what the document is.
she's got that in her possession. Why don't you go ahead and take it down from the jury? Say, go ahead and get it into evidence, and then you can publish it. So instruct your witness to pull it up, and then we can get it into evidence. But remember, we specifically talked about that.
Apologies, Your Honor.
It's okay.
Ma'am,
28:30 remaining.
Take a look at exhibit 14, please.
Okay, one second. I have it up.
You recognize that, right?
Yes, I do.
That's from an employee to your company, right?
Yes.
Ma'am, that's a fair and accurate copy of that employee's complaint to you, right?
Yes.
It hasn't been changed in any way. That's
No.
it. Your Honor, we offer exhibit 14.
Any objection?
no objections.
Okay, it's admitted and you can publish it.
This person says that they were injured on the same staircase that we're talking about, right?
Yes.
They say there was no light, right?
Yes.
They say there was no handrail.
Yes.
Now, this employee told you it was dark outside when I opened the door and the light wasn't on, right?
Yes.
I told you there's nothing for me to grab onto, so I couldn't stop my fall, right?
Yes.
Ma'am, at the bottom there are some comments from your manager. You see that?
I do.
It asks, are there any steps that should be taken by Chimes to help prevent such injuries like this in the future, right?
Yes.
Could you read your manager's answer, ma'am?
It says, make sure there's adequate lighting on the loading dock.
Ma'am, you received this document more than 10 years ago.
Yes.
10 years later, there's still no light switch in your store.
Yes.
10 years later, there's still no guardrail on those stairs.
That is correct.
Thank you, Your Honor. Pass the witness.
26:35 remaining. Okay. 32:14 remaining for defense counsel. Any redirect?
Yes, Your Honor.
Okay, whenever you're ready.
Ms. Keller, why did you have the guardrail removed from the stairs as well as from the dock?
Well, so sometimes, as the picture that they showed me on cross, sometimes you do have like employees that just come up and you're loading it like that. And so in that instance, the stairs aren't used. But sometimes we do need to use the entire length of that whole area, including the stairs, to be able to unload stuff properly. So we needed to make sure, in order to utilize it as a true loading dock, that the whole area was unguarded.
And even though that outdoor light didn't work, was there any other source of light for the outside?
Yes, as we talked about, the doors swing completely open to where they're flat on the wall, and the light from the store just comes out and floods the whole area.
Thank you. That's all.
Okay, 3119 remaining. Okie dokie. Anything further from defense?
Your Honor, apologies. We have a recross of the
Oh,
witness.
sure. Give me 1 second. I'll reset your time. So let's see, 26, 35. I'm sorry about jumping the gun. Whenever you're ready.
Thank you, Your Honor. Ma'am, Ms. Forrester just asked you about your use of the loading dock and the use of the stairs. You just told the members of the jury that you needed to use those stairs in order to load things from trucks, right?
Sometimes, yes.
Mr. Beachy, could we have exhibit 33, please? Ma'am, you're telling us that there can't be a guardrail for those stairs? That's your testimony?
I agree that in this picture, you wouldn't need the full length, but sometimes when we have the trucks pull up, we do need the full length of the whole area.
Well, let's talk about those trucks pulling up, ma'am. Now, you know that there are double doors in the back of your business.
Yes.
The width of that landing is the same as the width of those double doors, right?
Yes.
Anything you want to load into those doors, it has to fit in that landing. Isn't that right?
Correct.
And not the stairs.
Correct.
Nothing further.
2529 remaining. Anything further from this witness?
Oh, Your Honor.
May she be excused?
She may.
Okay, you are excused. Anything further from defense counsel?
A couple of things, Your Honor. First, we request that you take judicial notice at this time of a particular provision of law, and we're happy to share that on the screen.
Okay.
This is International Building Code 1012.1.
Okay.
Great.
Any objection to me taking judicial notice of that particular law?
No, Your Honor, other than the law only talks about the loading area, not the stairs.
Okay. So noted. It had been noticed.
Understood. And we'd also like to call a witness, Perry Hayden, by deposition.
Awesome. Let's do it.
Starting on page 2, lines 5 through 23. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Perry Hayden.
How old are you?
I'm 35 years old.
Where do you live?
I live in Austin, Texas.
What do you do for a living?
I am a compliance, safety, and health officer with the Occupational Safety and Health Administration.
What does the Occupational Safety and Health Administration, or OSHA, do?
OSHA is the government agency that's responsible for making sure that workplaces are safe for the employees that work there. So we provide information, training, and assistance to employees and employers to try to make workplaces as safe as possible and to make sure those workplaces are in compliance with OSHA regulations and standards. We're all about employee safety.
And what do you do at OSHA as a compliance, safety, and health officer?
I'm one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
Moving to page 3, line 16. How long have you worked for OSHA?
Since I got out of school. So at this point, that's about 13 years.
And over that time, how many inspections have you conducted?
Oh man, hundreds, thousands? I mean, the answer is a lot. It's basically my entire job. So I'm always out on the road inspecting somewhere. It's an everyday thing.
Moving to page 5, line 6. All right, Ms. Hayden, how were you involved in this case?
Well, I conducted an inspection at that Chimes department store in Waco back in 2018. So I assume that's why I'm here.
page 5, line 20. So were there any complaints that led to this inspection?
Not that I'm aware of. I went out there because it had been a while since we'd been there. That's it.
During that inspection, what were you looking for?
At the most basic level, I'm looking for any kind of condition at the workplace that might be dangerous to the employees working for Chimes.
Moving to page 6, line 11. Did you inspect the area behind the store where there is a little landing area and some steps?
Yes, I did.
Page 6, line 8. Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
And moving to page 7, line 16. Why does that matter?
Because loading docks don't have to have guardrails.
How do you know that?
Because OSHA says so.
Thank you. Pass the witness, so to speak.
Okay, 2739 remaining. Okay. Let's see, 2529. I assume you'll be crossing that witness.
Yes, Your Honor. Permission to have my co-counsel, Mr. Beachy, read
Absolutely.
portions and screen share for the members of the jury, just those portions.
Any objection to that, defense counsel? The sharing of the screen?
No problem.
Okay.
Starting on page 6, line 22. When you went out there, what did you notice about the steps and that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
Page 10, line 5. Do you disagree with the assessment of your boss in this email?
No, I don't. I am fairly conservative when it comes to issuing citations. Look, I obviously believe that workplaces need to be safe for employees, but that doesn't mean the government should be draconian in enforcing those regulations, especially in times like these when it's hard enough to find a job or a place to work. So maybe I'm a little bit more lenient than other inspectors. That's certainly possible, but I do my job and I do it well. And we talked about this issue and it was all good. It's not like I've been fired or anything.
Page 11, line 16. Did you ever inspect that area behind the store at night?
No, only during the daytime.
Your Honor, no further questions from this witness.
Okay, 2402 remaining. Anything further from our missing witness?
No, Your Honor, and nothing further from the defense at all. We rest our case at this time.
Excellent. Okay. I don't think we need to do another comfort break unless y'all are just dying. Can we just move straight into closings?
I would love a short break, Your Honor, just to grab some water.
Okay, let's make it quick. We can do another 5 minutes. Again, jurors, judges, if you leave, please turn your camera on. That way we're tracking that you're gone.
Sounds good.
There they are. All right. So 2402, y'all can do whatever you want with your cameras. If you want to leave them on, you know, I don't care. Or if you want to turn them off while you're not talking. So you've got 2402 left, Miss Holden. I'll start timing when you start going, okay?
Yes, Your Honor. The defendant made dangerous demands. And it started right away, just a few weeks after the defendant moved into the building. That's when they demanded that the only guardrail on the back stairs be removed. They demanded that that guardrail be removed even though they knew that those steps weren't well lit. They demanded it even though they knew their employees would sometimes be out there in the dark. They demanded it even though they knew that someone could get hurt without it. But we can be certain that they knew all of this because of Exhibit 14. This is an injury report from years before Ms. Gilmore was injured. An injury report notifying the defendant corporation of just how dangerous those back stairs were. It was dark outside when I opened the door and the light wasn't on. There wasn't anything for me to grab onto, so I couldn't stop my fall. So years later, when Ms. Gilmore was out there on the very same steps, in that same dark January night, you can be certain that the defendant knew just how dangerous their demands had been. But it didn't stop there, members of the jury, because what you saw today is that even after the defendant demanded that the guardrail be removed, that the stairs be more dangerous than they already were, even after all of that, they demanded that their employees use them. Told them that they didn't have a choice, that when they took a break, those were the only stairs they were allowed to be on. And when Ms. Gilmore did exactly that, when she followed the defendant's demands, she got hurt. Members of the jury, that's why she filed this lawsuit. And we, the plaintiff, today, we have a burden of proof. We are not going to shy away from that, members of the jury. We embrace it. We had a burden to show you that the defendant, a corporation, knew that that break area was dangerous, failed to protect its employees from danger, and that failure was the direct and proximate cause of Ms. Gilmore's injuries. Members of the jury, we showed you that today by showing you three things. First, what the defendant demanded of their landlord. Second, what they demanded of their employees. And finally, the little that they demanded of themselves. So let's start with the first, what they demanded of their landlord. You heard today the reason why Ms. Gilmore fell. The reason we're here in court today is because there was no guardrail. I mean, think about it. If everything were the same lighting, the same door positioning, the same wind, the same stairs, and Ms. Gilmore slipped, but this time there was a guardrail to protect her, she just wouldn't have fallen. It's simple as that. That guardrail, she could have grabbed it, members of the jury, and at very least, it would have stopped her from falling over the edge. So when the defendant demanded that their landlord remove it, they made those stairs more dangerous. They turned them into an accident waiting to happen. You heard that from an expert witness today, Mr. Daines. He's an expert in workplace safety standards, and he explained to you just how dangerous that demand by the defendant was. He testified that it wasn't just dangerous to remove that guardrail. It violated government regulations about workplace safety. It violated OSHA rules about what steps employers had to take to keep their employees safe. Well, you heard today from a defense expert as well. But even that expert admitted that when she saw those steps without a guardrail, she was alarmed. She called the lack of a guardrail a pretty obvious problem. Those were her words. And that's what every single witness in today's case, everyone except for the owner of that department store, agreed on. The lack of a guardrail was dangerous. Demanding its removal was dangerous, and whatever the defense tries to say today, that's one dangerous demand the defendant just can't take back. Which brings us to number 2, what the defendant demanded of their employees. We know that those employees were required to use those stairs. The defendant demanded, you'll have Exhibit 1 to take back with you to deliberations. You can see exactly what that employer told their employees. That if they wanted to take a break, if they wanted to go outside, they had to go to the back. They had to use those dangerous stairs. You also heard about other demands. Well, on cross-examination, Ms. Geller told you that it was the employee's job to tell them about safety violations. They said, we don't have a safety policy. We don't train our workers with safety. It's the employees who have to tell us about safety violations, members of the jury. In opening statement, Ms. Forrester told you that the stairs were safe as long as the employees were. But ladies and gentlemen, think about who they delegated the safety of their store to. The employees. This defendant demanded that their employees look out for safety issues when they wouldn't themselves. They demanded that their employees tell them if their loading dock was crumbling. It demanded their employees tell them that if they should have a statutorily required guardrail up. And why? You heard the defendant herself. Well, I just don't consider my business a safety company. But that's not all that company demanded of their employees, members of the jury. Well, this was a big point for Ms. Forrester on cross-examination. She asked my client about a cell phone. She asked, ma'am, you knew it was 7 p.m., didn't you? You knew that it was dark outside, didn't you? Why in the world didn't you bring your cell phone out there and shine that light from your phone? Members of the jury, I want you to think about that. Think about what the defense is asking of an employee, of a worker, of a cashier at this store. The employee is supposed to provide light to see at the defendant's company. The employee is supposed to bring her personal cell phone outside where the defendant sends her, where the defendant sends her at work on the job, to those dangerous stairs at night with no railing, nothing to hold on to every day for 10 years. No wonder someone got hurt, members of the jury. In that darkness, that was inevitable. Members of the jury, there was more light coming from that cigarette that the plaintiff threw out of the dumpster than the light that was provided by that defendant. And that's just the tip of the iceberg for how little they demanded of themselves. Because 10 years ago, over a decade ago, the defendant knew that those stairs were dangerous, knew that the lighting on those stairs were dangerous, and still for week after week, for month after month, for year after year, sent employees out to that loading dock. Members of the jury, you don't have to take my representation that the lighting on that back area was dangerous. You can believe the defendant themselves. Look at their own statement. What can Chimes do to prevent something like this from happening in the future? This came from the manager of the defendant, directly to the defendant. What are her words? Make sure there's adequate lighting. They knew it 10 years ago, and they knew it in 2019. They just didn't care. Find the defendant liable. Thank you.
Okay, you've got 12:53 for your rebuttal if you choose to take one. $27.39, a good half-hour closing, I assume that we're about to have. Just kidding.
Promise not to use all of it, Your Honor.
You can do whatever you need to do. All right, whenever you're ready.
Those steps were safe, as long as the employees were safe. Today, you heard about Chimes Department Store, that locally owned store located right downtown. You heard about that loading dock that Chimes had at the back of that store. That loading dock that they've had, the loading dock that they've used every day, day after day for 14 years. You heard that the plaintiff herself, Jordan Gilmore, used that dock every day that she worked for 10 years. She told you herself she never once fell off that dock. 10,000 trips. She never once fell off that dock until January 23rd. You heard what was different that day. You heard that she walked down those stairs, smoked her cigarette, threw out the butt, walked back up those stairs. She had a choice. And she made a dangerous decision. But folks, just because she made that dangerous decision on those stairs doesn't mean the steps themselves are dangerous. Today, the evidence showed the steps were safe, as long as the employees were safe. And that is not what the plaintiff would have you believe. The plaintiff has brought a claim of negligence, alleging that what happened to Ms. Gilmore was actually the fault of Chimes Department Store. Now, it is the plaintiff who brought that claim, so it is the plaintiff who's got to prove it up. They have what we call the burden of proof. They had to prove every element of negligence by a preponderance of the evidence. They had to show it was supported by the greater weight of the credible evidence. You'll learn there's not just one, not just two, there are three elements they had to prove. Number one, they had to prove that there was an unreasonable risk of harm. Number two, they had to prove that the defendant knew or reasonably should have known about the danger. And number three, they had to show the defendant failed to use ordinary care to protect their employees. Now, if they failed on any one of these three elements, then you can't find my client liable. I want to talk about these elements. And I want to start with the first one, an unreasonable risk of danger. Unreasonable. That's important. The law doesn't require no risk of danger, only an unreasonable risk. Now, what does that mean? Unreasonable is a risk that's not outweighed by other considerations, benefits, necessity. So let's talk about those other considerations, because you heard about them today. Reese Geller took the stand. You'll remember her testimony. You'll remember her talking about her grandparents opening up that store so many years ago. You'll remember what she said about when that store moved to its new location in 2005. You'll remember she said, you can't run a department store without a loading dock. And you can't have a loading dock without a railing. It just doesn't work. Simple as that. Now, of course, maybe it would be a little safer if there was a railing. But if there was a railing there, well, the store wouldn't work. Ms. Gilmore wouldn't have a job. That is exactly the kind of risk that is justified, that we live with every single day of our lives. And that is exactly what the law says too. You will have the benefit of this law when you go back later today. You will see that the International Building Code, one of the codes that applies here in Waco, says that guards are not required on the loading side of loading docks. Folks, there was some dispute today over whether that meant just the flat platform or the stairs as well. But you heard two responses to that. First of all, you heard Ms. Geller tell you we had to take the railing down on the stairs. And that makes sense. Think about the things that they might be bringing into that department store, the kind of store that sells a bit of everything. Think about big flat screen TVs, big bulky boxes, sports equipment, baseball bats. You can think about employees trying to carry those things up those stairs. You can think about how a railing there would get in the way. But it's not just that you heard. You also heard from an OSHA inspector, or you heard from his deposition at least. You heard that OSHA inspector say that OSHA doesn't require a guardrail around loading docks. And you heard that OSHA inspector actually went to look at that loading dock. He took a look around. He saw there was no railing on the dock, no railing on the stairs. You heard he gave him a clean bill of health. So the plaintiff can say what they want about the law, but OSHA themselves said that that was just fine. That's how you know that not having that railing, that's just not the kind of risk that's unreasonable. Now, we heard a lot today about the lighting as well, whether or not the lighting in that area was adequate or not adequate. And folks, it is certainly true that there was a light outside that building that couldn't turn on. We don't dispute that today. But that fact alone does not necessarily mean that the lighting that they did have wasn't adequate. And you heard that there was some lighting. You heard that those doors, when they were thrown open, to use Ms. Geller's word, the light would flood out from inside. It would flood out onto the landing dock. If that door was all the way open, the light could flood out onto the stairs. Now, folks, I want you to think about this for just a second. You saw a lot of photos today of that landing dock, of the stairs. Every single one of those photos you saw was taken in daylight. I want to be clear about this. It is the plaintiff, not the defendant, who has the burden on this point. The plaintiff did not bring you a single picture of that landing dock at night. They did not show you that light streaming out of those open doors was inadequate. They didn't meet their burden. We're not saying there was no risk at all. Folks, you know, every time you go up any set of stairs, there's some risk. Every time you get in your car to drive somewhere, there's some risk. We're not saying there was no risk. We're saying the risk that was there was necessary. The risk that was there was reasonable. The plaintiff failed to meet their burden on that first element. And because they had to prove every one of those elements, folks, that's it. Show's over, case closed. But in case you have any lingering questions, any hesitation, any doubt in your mind, I'll keep going. I'll talk about that second element. Plaintiff's counsel had to prove that the defendant knew or should have known about the risk. You just didn't hear that in the evidence today. Think about what Reese Geller said. I asked her in those 14 years that she had had that loading dock looking the exact same way, had anyone once come to her with an issue? She said no. And think also about that OSHA inspector showing up, taking a look around, examining that back area, signing off on an inspection report, a clean bill of health. That inspection report, that means two things. One, it means that area wasn't dangerous. And two, it means that Ms. Geller and the folks at Chimes, they had no reason to believe that that area was dangerous. They had no reason to know. There was no way that they should have or could have known about any kind of risk. Folks, the plaintiff failed on that second element as well. We can talk about the third element for just a moment. The plaintiff had to show that Chimes failed to use ordinary care to protect its employees from an unreasonable risk. Folks, we already talked about that unreasonable risk. I told you that there wasn't one. You saw that in the evidence. There is no duty to protect from a risk that doesn't exist. They didn't meet their burden there either. The evidence showed those steps, they were safe. If the employees were. But you heard that Ms. Gilmore wasn't safe. Now, folks, this is not easy. Whenever anyone gets hurt, of course it is difficult and painful to say that that person might have been responsible for what happened to them. But here the facts demand that we do that we look at Ms. Gilmore's actions. Now the standard here is simpler than the standard for Chimes' negligence. Here we had the burden, and we just had to show you that Ms. Gilmore didn't act with the ordinary care that an ordinary person would have had in the same or similar circumstances. I want you to think about that. I want to put you in that moment to make you think about the choices Ms. Gilmore had. You heard that she walked out that day knowing how dark it would be because it had been just as dark every other time she'd gone out there at night. She didn't bring a light with her. You heard she smoked her cigarette, threw away the butt, went to walk back up the stairs, and you heard that the door, it was 90 degrees from the building. You saw those photos of it sticking straight out. It was blocking most of her walkway. And so as she's walking up those stairs, she's looking at that door that's right in front of her. Well, she has a choice to make. And she has a few options. Option number one, she can go ahead and push that door closed, right? Get it out of her way. Or she can ask her coworker who's standing right there to close it. Option number two, she can pull that door toward her, or she can ask her coworker to push it all the way open. She'll get more light this way from inside the building. She's got a clear walkway. Then there's option number three. Just leave that door where it is. Try to skirt around it in that 12-inch gap you've got between the end of that door and the edge of that dock. Folks, of her 3 choices, she made the most dangerous one. That's not ordinary care. Now, the plaintiff today, they've said that Chimes made dangerous demands. Dangerous demands. What demands? They didn't demand that Ms. Gilmore go smoke a cigarette. They didn't demand that she do it in total darkness. They didn't demand that she tried to jump around the edge of that door instead of just giving it a push. Folks, this case isn't about dangerous demands. It's about a dangerous decision. Ms. Gilmore's dangerous decision. Of course, employers have a responsibility to try to keep people safe. But folks, you know as well as I do, you knew before you turned on your computer to log into this trial today, that every person on this earth has a responsibility too. We have to be responsible for ourselves and for our actions. Ms. Gilmore has to be responsible for hers. When you go back to deliberate, you're going to get a form that looks like this. You'll be asked this question: whose negligence caused the injury in question? And because of what you've heard, because you've heard about those steps, you've heard there was adequate lighting, you've heard there were no problems before, you can mark no 4 times. Because of what you heard about Ms. Gilmore, those choices that she had, and the dangerous decision she made, you can mark yes for her. The steps were safe if the employees were safe. We'll ask you to find Chimes not liable. Thank you.
Okay, just as a data point, you had 12:22 remaining.
Thank you very much, Your Honor.
Mm-hmm. Okay, so 12:53. And whenever you are ready, Ms. Holden.
Thank you, Your Honor.
Mhm.
We told you all day about the dangerous demands that the defendant made. And I want you to think now about what the defendant is demanding of you. Because although defense counsel didn't really mention it in their closing argument today, they had a burden of proof too. They took on an affirmative defense. They had to show you that Ms. Gilmore was negligent. And I want you to actually think about what that claim entails, what the defense is asking you to believe today. The defendant today is trying to get you to believe that the person who fell off those stairs is negligent. And for what? For walking up the defendant's staircase? For tripping on the defendant's crumbling stairs in the dark, where the defendant should have provided a light in an area that even the defense OSHA inspector said was a problem? Was alarming? Members of the jury, their argument, it doesn't make any sense. They told you that because Miss Gilmore went to that dock time and time again, I remember they told you 10,000 times, that meant that it was safe. That meant that falling down those stairs was her fault. Members of the jury, you don't say, oh, you walk past that spike pit every day. You walk past that quicksand every day, so it must be safe. And it's true that those stairs aren't a booby trap, but that's the point. That when someone is told to go there every day by their employer as a condition of their employment, those risks, they add up. Because the defendant today, they just didn't meet their burden, but we did. Because when the plaintiff was going out on her break. She certainly didn't expect to end up broken. Miss Gilmore, she was being safe, but the defendant's stairs, the defendant's lighting, the defendant's back alleyway, that just wasn't. And that's why they're liable. Thank you.
Okay, 10:07 is what you had left, just as a data point. Okay, so we're going to go tender our ballots, and then when we get back, we'll do some brief commentary. Y'all did a very good job. Thank you. Okay, so we're just waiting on Mr. Jacobs' ballot, and whenever that's tendered, we can start critiques.
Sorry, I just sent mine in a second
Excellent.
ago.
Okay, just wanted to make sure that we didn't unduly influence you with our
It's gone.
very persuasive criticisms. Okay, if y'all want to turn your cameras back on, ladies. Let's see. There's Miss Jenna. Okay, so very good job. I'm going to be rude and I'm going to go first. I'm going to scurry out of here afterwards. Once the critiques are done, everybody's free to go, judges included. Okay, so I thought this was a good round. Instead of just piling on praise, I'll talk about, things that I think you can improve on going forward. The theming for, I don't know why I'm doing defendants first, but the theming for defendants, I didn't really love that. Although I will say that plaintiffs didn't make as much hay out of it as it probably could have been made. The, steps are safe as long as employees are safe. I just started thinking of like all the examples of things that you could say that about that would be like weird, like it's safe to drink and drive as long as you don't get in an accident. Although you did make some hay out of it in the rebuttal, which I thought was pretty funny. I laughed at the quicksand and the spike pit. Interesting to go the Indiana Jones route with that. Let's see. Plaintiff thought the graphic overlay thing was cool. Just wanted to mention that. The one thing that I would mention for plaintiff is intonation variance a little bit. One thing that I would say that, compared to defendant, that was a little bit noticeable is that, defense counsel intonates, there's a lot of variation, right? And so especially when we're doing things like reading a deposition into the record, it's a little more engaging because there's, some variance in her tone. I think that, the tone that you tend to use, plaintiff is very, it's like, a lot of gravitas, this is a serious thing, which is fine. But, some things aren't all that serious. And so, just varying a little bit of the slow, deliberate, this is very serious just every now and again, when we're not talking about something serious, it just, it also highlights those things that you want to lend the gravitas to. Nobody invoked the rule, and it was interesting that, I think defendant, made some use of that. Was a defendant that was asking? Yeah, I thought that was fairly interesting that that happened. Of course, the big thing in the round that we have to talk about is that graphic overlay about, couldn't you have just cut the railing in half? And I thought that was devastating. Also, brilliant recross. Normally you don't want to go for the double dip there, but what a great time to do it. And you kept it short too. Just okay. Well, the truck could back directly up to it. And, I don't know what I would have done there, but maybe, I think defense counsel, you could have made maybe some slightly better examples of, you kind of batted around it a little bit, the TV box. I don't know, people might pass something across the stairs to one another. There's something that you could argue, you wouldn't want the railing there for. But I thought you really blew that apart. I thought the graphic was really good too. Really good use of a graphic. So all in all, thought it was really fun, enjoyed watching it, and best of luck to both of you going forward. Thank y'all.
I guess I'll go. Just going off what the judge just said. What I was expecting you to do was say, well, the truck can't back up to it, no matter whether we're carrying tiny little boxes or giant TVs. It's the truck that needs to back into that space, and the truck is too big, or something like that. I wholeheartedly agree with the judge's comment about the theme, and defense, I'm going to pick on you a little bit. But my fundamental criticism about the theme was that those are the first words out of your mouth. And I didn't know what the case was about from your perspective from just those words. It wasn't until you explained it, right? My view on those first words out of your mouth, or any sort of fundamental theme that you're trying to weave into a trial, it has to be, you get it without any explanation. You understand what you mean. And it's the word safe. You don't really understand. The employees are safe. What do you mean? Are they dangerous people that you're hiring? Like, I didn't understand that part. So that would be what I would say for you. On the flip side, what I really liked about your both opening and closing was the use of the jury instructions. You're going to the elements and saying, okay, look, this is what the plaintiff has to prove. This is what I have to prove. And then in closing, actually show, I would do that on both sides, right? Like I would say, look, at the end of the trial, members of the jury, here's the box that you're going to have to fill out. You're going to have to write yes or no here. And let me tell you why the answer here has to be no, or whatever it is, or the number that you put in this box has to be this for the plaintiff, right? And for the plaintiff, that's what I would say for you is actually use what, I don't know what materials you have, whether they gave you a jury charge or something, but you can, do sort of similar what she did, just a PowerPoint slide of the elements that you have to prove, or the specific language that has to be used in reaching whatever conclusion the jury needs to reach. The other comments I had, I felt like the trial was a little light on evidence and objections. I did like the photoshopping that the plaintiff did of the red stairwell. I thought that was a great creative use. Similarly, anytime that you can, show and tell what the point you're trying to make, defense, I would, take every opportunity. If there was a way for me, after you get through the sort of the pleasantries of what I call the small talk of direct and cross at the beginning, if I could be using some demonstrative, whether it's physical or picture or whatnot, I strongly believe in the use of both, again, show and tell what you're trying to say. The other, I don't know. I don't know how detailed these were. The other sort of things that stuck out two other things that stuck out to me. The judicial notice of the building code, I thought that was objectionable. It's simply because you're trying to sneak in expert testimony when you don't have expert testimony, right? Like, and we got to see it for like a second, and I don't know if we as the jurors were supposed to be paying attention to that, or what the purpose of the judicial notice was for us in this fake jury role was, right? But I just assumed that we were seeing it as the judge was seeing it, and plaintiff, that would be, I think that's objectionable, right? Like, they're basically backdooring expert testimony in through the judicial notice, and they haven't met the requirements for judicial notice to sneak that expert testimony in, right? Like, they have an expert, they have deposition testimony, they could have asked these questions about the expert, and that would have given you an opportunity to cross-examine that OSHA guy about these questions, right? But they didn't do that. Instead, they just want the judge to put his stamp of approval on this OSHA regulation without any context at all, right? How do we know that this OSHA regulation even applies to this particular stairwell? We don't, right? And it's an opportunity for you to make a great argument about how their arguments are BS, right? But stepping back, I agree with the judge. You guys both did a great job. I'm sure you're going to do really well in this competition. So kudos to all of y'all. I'll go on mute. Let someone else talk.
Danny, you want to go? You want me to go?
Kimberly, you go.
Okay. I will be quick because I don't want to repeat. First off, I do want to commend both of y'all for doing this on Zoom. I thankfully have not had to do a jury trial, but just contested hearings and depositions have been enough to tell me that I never want to do a jury trial via Zoom. So great job with that. My two comments, I'm just going to limit to one for each of y'all. Plaintiff, use your client's name more. You are in a position to really personalize your client. You want the jury to like them. So don't say plaintiff did this. Use her name. So that it's okay to say defendant because you don't want to personalize the defendant. But I heard you say plaintiff a lot, and I was just like, look, it's a jury. They're going to be thinking of her as a person, not this, nameless, faceless plaintiff. And then for defendant, my recommendation kind of goes to what the judge and what Tom were just talking about. If you know that there's going to be an issue like with the railing, don't wait until redirect. Don't give the plaintiff's counsel the ability to bring it up first on cross and force your witness to deal with that in leading yes or no questions. Address it on direct. It's still going to come up on cross. You're probably still going to need to do a redirect, but don't give the plaintiff the first bite at that issue. And I felt like your redirect did get to the issue of the railing a whole lot better than it was ever discussed in the initial direct. And it doesn't have the same impact when it's following that cross. Those are my comments, but I do think y'all did a great job in a very weird and somewhat difficult setting. So good job.
Lori, why don't you go ahead?
Okay, I've just got a couple of quick observations. Same thing with everybody else. I think that there's been some really good feedback. So I tried to do one good and one bad for each of you, and the bads are just, you could do a little better with this. Joy, I think you made some really good choices in organization, your cross-examination and the redirect on the cross. I think you did a really great job with that. And it really built up what you were talking about. My room for improvement would be a little better storytelling, and I agree with Kimberly about the personalization. You've got a client who's hurt and you want us to care about that because we're still jurors and we're still going to be swayed by the emotional stuff. It's fine that they're monsters. I got that. Yay, you did that well. But I didn't get a real good sense of your client or the impact of any of this. And that's an important, sorry, I have a bug. That was important for me to hear from you, and I didn't quite get that. And Jenna, I'm going to say, I'm going to kind of switch those for you. I think you did a great job of storytelling. I like that you gave us options. She could have done this. She could have done this. She could have done this. Yes, she could have. They should have had a light. They should have had a railing. They should have done all those things. But I thought you did a good job of walking us through all the good options she could have taken to avoid that. So I thought that went very well. And I agreed about the discussion on the burden of proof. I thought you did a great job with that. The visuals were good and the explanation of it was good, particularly for a jury, because they're usually a little unclear about kind of what they're supposed to be doing. So I thought that was helpful. As far as a little improvement, you have some room to have a little more sympathy for the plaintiff. I don't mean cry for her or anything like that, but there were a couple of times in cross where she answered your question and then said something else, but you went back once or twice to say, so that's a yes, so that's a yes. I think she flustered you a little in that end, because if you got your yes, go ahead and move on to the next thing. If you're going to ask her for it 3 times, then your jury's going to start thinking you're badgering her. I don't think you did, but that's just sort of something to watch out for. Otherwise, I thought you ladies did a really great job. The visuals went well. You went with them. I think there was maybe one technical difficulty, and you handled it exceptionally well. So excellent work, and I'm going to shut up.
So I'll be honest, I don't want to try a case against either one of you. I thought you both did a really, really good job, but I'm going to be hyper technical and I'm going to pick on both of you a little bit about just some ticky-tack stuff. Okay. Joy, you need to clean up your evidentiary stuff a little bit. For example, you were asking the witness about whether you were proving up a document, right? The term is true and accurate depiction or true and correct copy. I can't remember what you said, but it wasn't either one of those. If you run into a hyper-technical opposing counsel, or if you run into a judge who likes specificity, you're going to have problems because you're going to end up with an objection on that. So it's not a big deal, but that's just something to think about. I want to talk with, Jenna. Let's talk a little bit about, and this goes for Joy as well. I don't know what the packet says about the taking judicial notice, but I tried a case a month ago in federal court, and this was a big issue in my case. Okay. One of the things that can happen is you can have a statute that you want to take judicial notice of that shows that it's an older statute, right? It's not always going to show that it's a 2021 statute, right? This particular statute shows that it's a 2003 statute, right? So I don't know what the packet says with regard to that, but if I'm Jenna, that's the first thing I am saying, is that this is a current statute applicable at the time of whenever this injury occurred, right? Because The judge is evaluating whether or not this has any relevance to what's going on. I know that that says a 2003 statute, so you need to make clear to him this is what was applicable. And Joy, you need to call her out on that and say, look, this is a 2003 statute. There's no evidence that this was applicable at this time. And like I said, the packet may clarify that issue. This is more of a real world application because y'all are going to have to do this someday, but you just need to recognize those types of issues. This could potentially be the difference between you getting it in and you getting it out. The other thing I'll say about it is it was kind of weird timing when you brought it up, because I thought it's kind of a stronger point for you, right? Like there's a statute that says I win in this case, but it's the last thing that you talked about. You might introduce it at the beginning and talk with your client about it. You know, it may not be in their packet, but if it's that important to you, then have something in there that ties it into the testimony rather than just dropping it in. Okay. Otherwise, good job. I hope y'all go practice somewhere other than Texas so I don't have to see you in the court.
Thank you all so much for judging.
Thank you. And good luck to you, Joy. Great round.
You too.